from supplementary submission item 2 case BA 4358 of 2026 along items 3 and 4.
Your ladyship, I have seen the order passed by ladyship. My only contention would be, your lordship, all these matters, the members of the Advocates Association had stated in para 2 that they had moved and withdrawn. Secondly, most of them had false.
No, we are not on any particular case. You see, it is not a matter of cancelling anybody's name or cancelling anybody's bail or making any aspersion to anybody. But this has happened, which has come to my light, so I want a solution. I want a solution to this, and I have come to know that different benches are taking different view.
Yes.
So
this will have to be done.
And you see, madam, whenever this, you have also practiced, we have also practiced together for years together, right? Whenever any bail application is rejected, firstly, it is the duty of the office to take care of it.
Yes.
Right? We will take care of our office. And in case it is listed, by any chance, by whatever be the reason, I don't want to go into that. The opening sentence of the advocate is it has been earlier rejected. Invariably. Am I wrong?
No, Your Honor.
And I remember in prior to creation of state of Jharkhand also, even during the vacation, the moment, because at that point of time there was no such computer system, the moment a counsel used to say it has been previously rejected, the case was used to be adjourned for reason. And as per the notice, during vacation, it was clearly mentioned that if there is any urgency, it has to be listed under the orders of the Honorable Chief Justice. So I have to yet find out if there is any specific order of the Honorable Chief Justice. Madam, what message is going? Our entire criminal service, our entire criminal jurisdiction it will crumble down. And if this happens, then for the entire year, or maybe for previous 5 years, anybody's bail is rejected, he will come and move during the vacation and he will be granted. So vacation court will be the appellate court. Vacation court would be the appellate court.
Yes, Your Honor.
Then?
Your Honor, my only humble submission would be this matter has to be taken care on the administrative side.
No, I will take care of it on the judicial side also, because the state council do not point it out.
Because I have gone through.
State councils have not pointed it out. So I have to take care of the state, and I have already said, if the litigant is there, he is in jail, he will do whatever he wants to. I don't want to say anything, he is beyond my control, he is already in jail. I don't want to say, I don't want to comment anything. But what about the state council?
I'll just say 2 things. I have gone through a few of the orders, Your Lordship, in which the Honorable High Court has noted it was earlier.
Only 2 orders.
2 orders, yes.
What
It is
about the
there.
rest?
It is there. And in all the cases, ladyship, they had stated this in para.
Madam, in
And
the
second thing, Your ladyship will take into consideration, I think in 23-24, if I'm permitted to take the name, when Justice
please do not take the name.
one of the acting chief
I am
justice.
aware that Bard is speaking about that.
No,
I am aware that there was some order. But where is that order?
it is with the registry.
No.
ladyship.
It is not.
Because it was.
I have
an
inquired at my,
administrative-
madam, you see, in the list, I'll tell you what is there, which is moving in your mind. In the list, constitution is there for the week. At the bottom, there is a note. Right? That these are the instructions, tied up matter, not tied up matter. At that point of time, numerous bail applications were pending before this court. So there was a note at that, in that particular list. With that list, with that note, it was printed.
I'm not aware.
I'm telling you, the registry will put everything on record. Because we have done our homework before passing this order. Correct? And then what happened? When the next constitution came, that note was not there. There were different set of notes. So can we say that that note was continuing?
No, we cannot.
You cannot say that. And secondly, apart from this, there is a judicial order deciding this point.
Yes, that I've got, madam.
Clear judicial order is there. Clear judicial order is there.
Yes, I've got it.
Yes. Yeah, I know. It is there. I'm aware. that
We also
must
try
be
to
aware.
do our homework. We also try.
Madam, my concern is the discipline amongst us. We amongst us means all of us, right? So it is a huge. You see, on 15th the case is withdrawn. Same counsel, same Padvikar files bail application on 18th, right? So what do I tell? Am I a fool sitting over here? If you do not like the bench, please go to the Honorable Chief Justice and ask him to do the needful. Whatever assignment has been given to me, I will do it as per my wisdom. And I will not do it to please anybody.
As far as the statement of your ladyship is concerned, I can say with full responsibility that the members of the Advocate Association is very happy and satisfied with this bench.
Madam, I am
With
not.
due respect,
We, madam, we are
because it
all
has come
here.
from your lordship's
We are all here only to satisfy one thing. That is the law. We are not here to satisfy anybody. We are here to satisfy our conscience and the rule of law. And you see what I'm given. I'm given the code of crime against women, right? In case of gang rape, in case of death of bride within 2 months, 3 months, right? There are numerous orders of the Honorable Supreme Court setting aside such bail orders. I think recently also few such orders have come. These are very serious offences. We can't shut our eyes to all this. And therefore maybe that the ratio of bail given by people may be less. In cybercrime, I'll tell you what happened. Everybody knows this. Everybody in the bar knows this. I had disclosed my mind that at the first instance, I will not grant bail in cyber offences to those who have a criminal. I told them frankly, you come later, I'll give you, because there has to be some distinction. There is a repeat offense. I granted bail invariably. You know, so many crime links found, hundreds of crime links found, but still I granted their bail because I had adopted a gangster. So the moment they came to know about it, the cases in which there was criminal antecedent, those were withdrawn, and it are those matters which have been refiled. Right? So it means a court should not disclose its mind. A court should have arbitrary parameters and should not be predictable. It is it. You see, if a person of 1 day's practice also comes to me with a similar case, I can guarantee you I will have the same answer. I made and in some of the cases, second time they have moved and have granted.
And your lordship with criminal antecedent also, if the lawyer has been able to make out a case,
Yes.
your lordship ladyship has been pleased to grant bail. It is not that.
So, and
it is
madam,
not that.
arguments, and I think in a court of law, argument of both the parties is required to be considered. I can't be one-sided. Maybe bail is the rule, but I have to give an opportunity to the victim. I have to give an opportunity to the state. If the petitioner says that I have no criminal antecedent, the state has got a right to verify whether he has a criminal antecedent or not. I am getting such orders for modification where he has made a statement that there is no criminal antecedent, and I have passed an order asking the court to verify, and if there is no criminal antecedent, then only he will be reviewed. And then the criminal antecedent is there. They are coming for modification of the order, which I have refused. So Padvikar, I will not say anything, impute anything on him. He may not be knowing many things.
Like the lawyers.
Like the lawyers. He may not be knowing anything. So this kind of situation, madam, is not, this is not acceptable to me. And I think, and this is the only way in my view, that a senior of 30 years of practice will be, when he is arguing a case, and a person of 1 day's practice, when he is arguing a case, he will have an equitable treatment so far as a case is concerned.
Right.
This is what I want. This is what I want. And nobody can say that any particular council or any particular kind or anybody has a special say in this court. I'm sure nobody can say that because I know that it is not. It can't be like this. And if we do not bend our ways, people are there to, the kind of what message I have got by this. I am told I have got this message from the jail that I am a very negative judge. So the cases should not be filed before me. They should wait for change of bench and many things. Right?
Well, Ladyship, that
I'm disclosing it to you. I'm disclosing my mind and heart to you because you are there, you would understand what I'm saying.
because lot of clients उनके यहाँ मत सटाइएगा.
Boleh.
They say.
They will say.
Not only you, lot of judges.
Lot of judges. There is no doubt on that. But when this kind of thing is happening, it hurts me. And not me personally, it hurts the system.
Institution. It should hurt the institution.
Yes. And I'm told that not only my bail orders, there were other judges' bail orders also.
Yes.
So, I don't know. One day, one counsel told me I earlier rejected on merits. He started the case on merits. Then, when I saw the bail order is there, so when I told him that your bail application has been rejected earlier on merits, he said I have stated in para 2, so I need not say so during the course of argument. I said okay. I had no idea that the bar has changed its style of argument.
That must be one lawyer, but everyone, most
So-
of us say
so
this is the second
that's
time.
right. But all the orders is only 2 of them are reflecting that there was
This
a
is for what
And
on the
in-
dash to record.
and in rest of the cases there is no such submission. In rest of the cases there is no such submission. Why? State Council submission, we only know the order. We don't know anything more. So you tell me what is to be done. You give it in writing, whatever you want to give, I'll incorporate. But you have to give it in writing. Written submissions you give. And registry members, you have given your report?
1 week time.
Okay. I'll give you 1 week time. You take care of the note given during vacation. And I'm correct that there was one cause list where there was an instruction. You put that also because she is indicating and we are aware that there was because this is the explanation they are giving. You just enclose the subsequent cause list also where there was no such instruction. Right? And you see, we are not against any staff, we are not against any council, we are not against any litigant, we are not going to cancel anybody's bail, we are not into all this. जो निकल गया ना उसको सांस लेने दीजिए हमें उससे कोई मतलब नहीं.
But for future it should not be repeated. This is what you are.
इतना नहीं सोचते ना कि निकल गया भाई उसका किस्मत में था निकल गया उसके जान के पीछे थोड़ी पड़ जाएंगे यार. And one more thing, I do not know, councils would be in a better position to say, in all the cases regarding POCSO and in other cases where there are serious offences and trial is going on, I generally do not permit bail, but at the same time, I instruct the State Council to ensure that the witnesses are promptly produced. And I am informed that witnesses are being produced.
Even in my case, your ladyship had passed this order and.
तो हमें क्या चाहिए भाई अगर हम आपको बेल नहीं दे सकते तो एक्सपीडिशियस ट्रायल तो दे सकते हैं ना. यहाँ से अगर हम ट्रायल कोर्ट को डायरेक्शन देंगे कि आप ट्रायल कंक्लूड कर दीजिए वो सही नहीं होगा. लेकिन अगर विटनेस आ रहा है तो ट्रायल कोर्ट के पास कोई ऑप्शन नहीं है रिकॉर्ड करने का, वो विटनेस को लौटा नहीं सकता है. इतना ही करना है. हमें क्यों देना है डायरेक्शन ट्रायल कोर्ट को कि आप ट्रायल जल्दी से कंक्लूड कर दीजिए? नहीं देना. हम क्यों देंगे? विटनेस आएगा तो ट्रायल कोर्ट अपने रिकॉर्ड करेगा. पॉक्सो में कितने विटनेस होते हैं मैडम? मैक्सिमम 5 विटनेस. द विक्टिम, द इंफॉर्मेंट, द डॉक्टर, द आईओ एंड एफएससी. इसके अलावा कोई विटनेस है? एक आध और होगा. और हमारा एक्ट में प्रोविजन है कि कितना दिन में ट्रायल करना, 6 months। 6 months का पॉसिबल नहीं है, 6 months में ट्रायल करना आराम से पॉसिबल कर रहे हैं आप लोग, सारे विटनेसेस आ रहे हैं, जितने भी डायरेक्शंस हो रहे हैं आ रहे हैं। थोड़ा आप लोग भी रिपोर्ट लिया करिए भाई, इतने सारे। तो आप हमें एक डेटा देंगे ना कि भाई यहाँ पे जो हमारे प्रीवियस ट्रायल कोड के डिस्पोजल हैं और अभी जो फ्रेश ट्रायल कोड के डिस्पोजल है मंथली 6 मंथली, कि भाई इस तरह के, क्योंकि हम तो ऑर्डर कर रहे हैं लेकिन इसका क्या इम्पैक्ट है इज नॉट नोन टू फुल्ली। ऐसे तो हम अपने एडमिनिस्ट्रेटिव जज हैं तो जहाँ से पूछते हैं तो वो लोग बताते हैं कि एकदम विटनेस हर डेट में आ रहा है, डे टू डे आ रहा है और विटनेस नहीं आएगा तो भाई हम तो बेल देंगे यहाँ से, फिर हम नहीं रोक सकते किसी को। विटनेस नहीं आएगा तो उसका अधिकार है ना भाई जेल से निकलने का, ये दोनों चीज कैसे चले? इट कैन बी। सो दिस मच ऑफ सर्विस आई कैन प्रोवाइड, लेकिन ये तो बहुत गंदा हो गया। आपको जो बोलना है मैडम यू कैन पुट इट इन राइटिंग।
हम तो केवल बोलना
नहीं,
चाहते हैं
नहीं,
मेरा
नहीं।
मेंबर लोग का
नहीं,
नहीं था रेस्ट।
मैडम हम किसी आप मेंबर को सिर्फ डिपेंड मत करिए, ठीक है? हम अपने ऑर्डर में भी लिखे हैं कि हम भी 2-4 ऑर्डर किए, लिखे हैं ना, बिकॉज आई डिड नॉट नो अबाउट, ऐसा नहीं है, आई हैव रिटन इट इन द ऑर्डर इटसेल्फ दैट ए फ्यू केसेस जब बेंच बना तो हमको नहीं पता, जो समझाया हम अपना समझे उसी अनुसार, उसके बाद जब ऑर्डर आया स्टॉप इट कंप्लीटली। ऐसा नहीं है, ह्यूमन एरर तो किसी से भी होता है ना, लेकिन मिस्चीफ नहीं होना चाहिए। आपको जो भी आप बार की प्रेसिडेंट, विद ऑल रिस्पेक्ट टू ऑल बार मेंबर्स, और एक चीज और हम आपको बता देते हैं, 2 चीज का हम और ध्यान रखें, बिकॉज आई नो कि हमारा बार बहुत सर्वाइव करता है, मैक्सिमम मेंबर्स आर सर्वाइविंग ऑन बेल एप्लीकेशंस। जिस केस में आउटराइट रिजेक्ट करने वाला भी होता है ना मैडम, उसमें भी हम केस डायरिंग कर देते हैं, बिकॉज आई नो दैट इट हैज अ वैल्यू। जिसमें काउंटर एफिडेविट नहीं भी करने की जरूरत है ना, उसमें भी हम काउंटर एफिडेविट का ऑर्डर कर देते हैं। क्या होगा, 15 दिन बाद सब देख के डिसाइड कर देंगे, लेकिन इससे भी अपनी रोजी रोटी चलती है ना मैडम, नहीं चलती है क्या? यू टेल मी, वी डू नॉट नो कि काउंटर एफिडेविट होने के बाद हमारे काउंसिल्स को कुछ तो फीस मिलता है। ऐसा नहीं है ना कि हम लोग नहीं प्रैक्टिस किए मैडम, आई नो द पेन, आई एम ए फर्स्ट जनरेशन लॉयर, राइट? अगर हमारे घर में एक पिन भी है ना, मेरे प्रोफेशन से खरीदा हुआ, एंड यू नो इट, कोई जाने चाहे नहीं जाने, लेकिन आप तो जरूर जानती हैं, राइट? You have seen how I kept my daughter locked in high court room,
Yes,
and used to come to the court, and Mr. Pankaj also knows it. इसीलिए हम एडवोकेट्स के पेन को बहुत बहुत ही ज्यादा जड़ से समझते हैं। जज बन गए इसका मतलब ये नहीं है कि आप लोग से दूर चले, आप लोग के बहुत करीब है, लेकिन इस तरह का जो प्रोपेगेंडा होता है ना, ये चीज हमको बिल्कुल नहीं पसंद। जेल से हमको खबर आएगा कि आपके यहाँ बेल नहीं करना है, तो ये तो सही नहीं है ना।
मुझे हम लोग का पहले जेल ही से बता देता कि रोस्टर में चल रहा है।
अभी तो ये बच्चे लोग तो क्या ही जाने, दे डोंट नो एनीथिंग अबाउट मी। इन्हीं जो सीनियर है उन लोग को पता है।
हमको याद है लिस्ट में जो बच्चा ड्राइंग
तो बहुत से लोग जानते हैं, बहुत से लोग नहीं जानते हैं, लेकिन एक वकील के तकलीफ को हम बहुत अच्छी तरह समझते, उसका फैमिली है, उसके बच्चे हैं, इसीलिए इस तरह का ऑर्डर कर देते हैं। चलो भाई आज क्यों रिजेक्ट करते हैं, 15 दिन बात कर देंगे, स्टेज भी आ जाता है, कुछ एक्सपेडाइट करा देंगे। ऐसा मेरा सोच है, कुछ गलत सोचे तो बताइए। नहीं, पॉक्सो में मेडिकल है, ये है वो है, सबको हम बेल देते बिना इंफॉर्मेंट को सुने, तो बहुत मुश्किल है मेरे लिए। हमको अपना भी जान बचा के रखना है ना, कि हम अपना हाथ जला दें।
ज्यादातर साइबर क्राइम में होगा,
वही आपको बता तो रहे हैं। आई टोल्ड एवरीबडी कि सेकेंड ऑफेंस में हम इमीडिएटली बेल नहीं देंगे, अभी आप देंगे, जिसका कोई एंटीसीडेंट नहीं है, हम सबको बेल देंगे, हम सबको बेल देंगे। हम बिना सोचे समझे ज्यादा नहीं देखे, जिसमें बहुत ज्यादा अमाउंट इन्वॉल्व था एक आध कोई मैटर, बाकी हम सबको बेल देंगे। यस, दिए है ना सबको, यही बोले थे ना कि एंटीसीडेंट में बेल नहीं देंगे। तो आप लोग सब क्या किए, सारा एंटीसीडेंट वाला केस विड्रॉ कर लिए, उसके बाद रीफाइल कर दिए, यही किए ना। बताइए,
में चार्जशीट सबमिट नहीं हुआ,
हम नहीं जानते हैं, हुआ यही है,
हुआ है।
यही हुआ। तो हम तो बेवकूफ बन गए, वेरी पे रिजेक्ट कर देना चाहिए, बोलते कि 6 महीना बाद आइए, वो ज्यादा अच्छा होता है। रिजेक्शन ऑन मेरिट बोल सकते थे ना। और मैडम एक चीज और बता रहे हैं, आज केस फाइल हुआ, 10 दिन के अंदर बेल एप्लीकेशन फाइल हो जाता है, ठीक है। साइबर ऑफेंस पे इन्वेस्टिगेशन में टाइम लगता है, और उसके बाद अगले 10 दिन में यहाँ पे केस आ जाता है, तो भी हम रिजेक्ट नहीं करते उसके, हम उसको चार्जशीट तक जमा होने के लिए एडजर्न करते हैं। आई कैन रिजेक्ट इट एट द थ्रेशोल्ड, अभी इन्वेस्टिगेशन चल रहा है तो क्या एंटीसीडेंट और क्या देखें हम, बट आई डोंट डू इट। सोचते चलो कोई बात नहीं।
मुझे इसके पीछे तो हम एक ही लाइन बोलेंगे जो आप भी सुनी थी, हमें लूज अ कोर्ट और लूज अ केस, ये वाला वही हुआ है।
भाई देखिए, आप लोग को नहीं बस देखिए, आप लोग का तो बहुत सेफ, आप लोग जज लोग से मिल सकते हैं, रिक्वेस्ट कर सकते हैं। आपको अगर मेरा बेंच नहीं पसंद है,
मेरा मेंबर से बहुत खुश है,
आपको अगर
क्या
मेरा
बोले
बेंच
आप?
नहीं पसंद है, तो यू हैव टू मेक अ रिक्वेस्ट टू द एप्रोप्रिएट।
People are very happy, very satisfied. It is not that, ठीक है, जिसमें बेल नहीं होना वो हम लोग को भी पता रहता है।
और कोई बहुत ही ज्यादा जूनियर खड़ा होता है तो हमको उसको उसके प्रति थोड़ा लगता है कि चलो अगर थोड़ा भी जगह है तो।
ये सब तो पुराना सोच है।
आपका 2 बेल रिजेक्ट हो जाएगा तो आपको फर्क नहीं पड़ेगा, एक नया एडवोकेट का एक भी बेल रिजेक्ट हो जाएगा, उसको 6 महीना तक एक भी केस नहीं होगा।
हो सकता है,
आती है।
हो सकता है वो डिस्ट्रिक्ट से
मैडम रात को 3 बजे फोन कॉल हम सबने रिसीव किया है, ठीक है,
तब लैंडलाइन होता था, पूरा घर उठता था।
पूरा घर उठ जाता।
अब तो 12 बजे रात में ये सब होना।
हाँ, तो आप खाली आप ही थोड़ी रिसीव किए हैं, हम लोग भी रिसीव किए हैं एज एन एडवोकेट। वो अलग बात है कि भाई हम क्रिमिनल साइड में नहीं प्रैक्टिस करते थे बिकॉज ऑफ माय पर्सनल
वही
रीजन।
से बोल देता है इस वीक में मत कीजिए, बेच बदलेगा। अब वो लोग को मालूम है।
सारा चीजें देखिए एकदम
नहीं,
इतना अच्छा
I
हमारा
apologize,
फैमिली।
whatever has happened, अगर ये intentionally हुआ तो it is very unfortunate.
आप लोग थोड़ा राइटिंग में दीजिए, ठीक है, whatever you have to say and what you have to say state.
Lord, certainly, Lord, it has to be pointed out. We used to point out before the Honorable Court in different benches, Lord, since it is Lord taken up some of the case, Court Lord was taking the, in spite of the submission made by the Lord Council of the State that it is withdrawn. Then also, Lord, since it was simplicity, Lord, it is our fault that we have not submitted as per the 2017 order, Lord. There was the order of division bench, Lord, it has already been decided that it is a tied up matter. If it is a simplicity withdrawal, it is a tied up. So, but because of certain confusion, my lord, later on, my lord, when the benches are taking the matters, when spite of the submission that it is a withdrawn, has already been withdrawn. So, it is our fault, Lord.
आपको जो देना आप लोग राइटिंग में दीजिए। अब एक पिटिशनर्स हैं, जो भी आपको देना आप राइटिंग में दीजिए। आई वांट इट इन राइटिंग, कोई कंफ्यूजन हमको नहीं चाहिए राइट में। और ये जो है ये अपना रिपोर्ट दे देंगे। डू यू वांट टू वेट फॉर द रिपोर्ट और यू वांट टू गिव इट राइट? यू कैन गिव इट, क्योंकि हम आपको बता ही दिए हैं कि जनरली रिपोर्ट हमें क्या
हमको जो बोलना हम लिखते
क्योंकि जुडिशियल साइड में कोई ऑर्डर नहीं है जहाँ तक हम, अगर मिल जाता है तो दे दीजिए मैडम, देयर इज नो प्रॉब्लम।
नहीं, जो हमको तो उनकी मैंने बाहर में पता चला था, हमको हम बेल करते हैं लेकिन कम करते हैं।
और बात का कैसे चल रहा है सर? यस मैम,
जी,
वी आर ऑल गुड।
we just got 10 senior designated seniors leadership after 18 कितना 10 साल 12 साल के बाद, so that's a very big thing. I hope and wish we get judges also. हम लोग हमारे बार का जज still oppose on the outsiders. और तो
आप लोग के यहाँ ना एक प्रॉब्लम है जो हमको लगता है जो सीनियर मेंबर्स है ना उनको कुछ एक ब्लॉक ऑफ जूनियर्स को कुछ दिन अपने साथ रखना चाहिए।
कुछ रब नहीं रहता है जैसे हम लोग के टाइम में जूनियर सीनियर को ज्वाइन ही करना होता था नहीं तो कुछ समझ में नहीं आता था आप सब बात क्या है सब अपने और हम लोग को भी समझा दें बाद में से
Okay. You just give it in writing whatever
Yes,
you have to say. I'm just posting it for the report of the
Okay.
MS Ritu Kumar, President of the bar, is present. Mr. और सबका appearance आप लोग हर एक appearance the registrar list and computer is also present in the court. It says that 1 week time will be granted to submit a report before this court. The learned president and the councils are directed to file their written submissions on the next, prior to the next day. 2 दिन पहले करना।
जी जी
Post this case on tenth of July
Okay.
in the supplementary office. Tenth.
Item 1 APA 1924 of 2026.
FIR starts at page 17.
Page 17.
Yes. And the relevant prosecution version starts at page 20. The litigation in brief, if I may say, or I will place in the
You just place the relevant.
the
There is
relevant
not much.
first page it will be very clear. महोदय विषय कैनरा बैंक ने शाखा हटिया में झारखंड स्टेट इलेक्ट्रिसिटी एम्प्लॉयज मास्टर ट्रस्ट के 9 करोड़ रुपए सावधि जमा राशि की जालसाजी एवं फर्जीवाड़े के संबंध में महोदय उपयुक्त विषय के संबंध में सूचित करना है कि मेरा वकील प्रबंधक लेखा राम रणजीत कुमार पिता सुरक्षित वर्तमान में झारखंड स्टेट इलेक्ट्रिसिटी एम्प्लॉयज मास्टर ट्रस्ट अभियंता और एचईसी दुर्गा रांची चार के पद पर कार्यरत है। निर्देशानुसार सूचित करना है कि झारखंड स्टेट इलेक्ट्रिसिटी एम्प्लॉयज मास्टर ट्रस्ट द्वारा कैनरा बैंक ने शाखा हटिया में 9 करोड़ रुपया सावधि जमा राशि की जालसाजी और फर्जीवाड़ा कर निकासी की सूचना प्राप्त है। दिनांक 30/9/2024 को श्री पी मधुसूदन राव पदाधिकारी कैनरा बैंक जोनल इंस्पेक्टर लखनऊ में उनके साथ कैनरा बैंक शाखा के वर्तमान शाखा प्रबंधक हम दोनों विश्वकर्मा कार्यालय में आए थे एवं चर्चा के दौरान उनके द्वारा विषय पर राशि के लेन देन के संबंध में संदिग्ध होने की जानकारी दी गई। श्री पी मधुसूदन राव पदाधिकारी कैनरा बैंक जोनल इंस्पेक्टरेट लखनऊ के द्वारा पत्रांक संख्या 16/30/24 के माध्यम से निम्न सूचना मांगी। Reason for remitting 9 crores to Canara Bank in branch manager. Second, as per discussion, it was informed by you that amount was sent for placing fixed deposit. In support of the same, please provide copy of the letter regarding following quotations definitively submitted by Canara Bank, copy of international communication, internal communication of finalizing successful banker from placing deposit on deposit receipt effectively. Also copies of check and letter directing Indian Bank Dhurwa to send RTGS to Canara Bank. Further, we are requested to confirm genuineness of all the above documents, whether all these documents have been properly authenticated by the authorized official or authorized person before directing banks for deposit. इसी क्रम में ऊर्जा विभाग की पत्रांक संख्या 16/1/2024 के माध्यम से महाप्रबंधक झारखंड पर्यटन विकास निगम लिमिटेड द्वारा संयुक्त सचिव ऊर्जा विभाग प्रेषित पत्रांक संख्या 10/73/24 की प्रति उपलब्ध कराई गई, जिसमें निम्न रूप से तथ्य वर्णित किए गए। निर्देशानुसार विषय के संबंध में सांसद सूचित करना है कि झारखंड पर्यटन विकास निगम लिमिटेड रांची के नाम से जालसाजी कर खाता खुलवाने एवं उस खाते में किए गए सावधि जमा के फर्जी होने तथा गलत तरीके से राशि निकासी का मामला प्रकाश में आने पर सचिव पर्यटन कला संस्कृति खेलकूद एवं युवा कार्य विभाग झारखंड राज्य को पत्रांक संख्या 16 के आरोप में प्रदेश प्रबंध निदेशक झारखंड पर्यटन निगम लिमिटेड द्वारा वर्णित मामले की जांच प्रतिवेदन विभागीय सचिव को उपलब्ध कराया गया। उक्त प्रतिवेदन में कंडिका 66 में फर्जी खाते में ऊर्जा विभाग से
The
संबंधित
account itself is forged as per the
Yes.
allegation.
As per allegation, earlier the amount was maintained in some other bank. Subsequently, a forged account was opened, and that 9 crores was withdrawn.
Who
This is
was
what-
instrumental in opening this account?
Initially, FIR was lodged against officer of the bank. Subsequently, in course of investigation, it has come that certain persons had conspired and opened bank account, and wherefrom it was withdrawn. With regard to this petitioner, he neither happens to be employee of the state, which is the department, nor employee of the bank. The name of this petitioner has come in confessional statement.
Just a moment. Confession statement of
Self-confessional statement recorded in other case. So, if your leadership had seen, this case pertains to Electricity Board Master Trust, and in second part of the allegation there is it is with regard to tourism department also. So, certain amount of tourism was also withdrawn. So, altogether 4 cases were launched. So, petitioner was taken into custody in one of the cases based on confessional statement of 2 others. So, in this case, the petitioner is being indicated on the basis of his confessional recorded in other case and also the confessional statement of other 2 people. That is what is the counter affidavit
is
says.
there any recovery? Is
No.
there any money paid?
No. Earlier case also I was taken into custody. I have been granted bail. I have the order. There was no recovery. There was nothing except confessional statement against me in those cases also. I have the orders also where I have been granted. In this case also, your ladyship counter affidavit has been found. And place entire counter affidavit word to them.
Let them place their account.
Only to submit to them. There is nothing except confessional statement of petitioner and that of court.
Yes.
I would only, my lords, for the convenience of this annual report, my lords, read out the confession of the co-accused who was instrumental and with whom the petitioner before your lordship hatched the conspiracy. Only the relevant extract I would read out, my lords.
This confession
My lords,
statement.
this is my lords Ajay Sen Gupta, my lords,
Just this confession statement has been taken in this case.
in this case, in this case. This is my lords Ajay Sen Gupta, alias Arnav Ganguly. Only the relevant extract I am reading before your lordship. इसके बाद समीर कुमार उर्फ रुद्र प्रताप के साथ मैं और कुशल बैनर्जी द पिटिशनर बिफोर योर लॉर्डशिप कैनरा बैंक निफ्ट ब्रांच गए। वहां पर बैंक मैनेजर अमरजीत कुमार से सारी बातचीत हुई। तब वह फर्जी खाता खोलने एवं रुपया ट्रांसफर करने की बात पर 10% राशि कमीशन लेने पर सहमत हो गया था। अमरजीत कुमार रात्रि में होटल एमराल्ड में डिनर पर भी आया था। हम सब साथ में डिनर किए। इसके बाद मैं वापस कोलकाता चला गया। कुशल बैनर्जी रांची में ही रहकर काम करने लगा। कैनरा बैंक में झारखंड टूरिज्म नाम से एक फर्जी खाता संख्या सच एंड सच 5910 खोला गया। इसके बाद हम सब इंद्रजीत चैटर्जी को बताया कि कैनरा बैंक में झारखंड टूरिज्म नाम से फर्जी खाता खोल लिया गया है। इसके बाद माह जनवरी 2023 में इंद्रजीत चैटर्जी मुझे त्रिदीप दास उर्फ बाबू के साथ रांची भेजा और बोला कि टूरिज्म विभाग से बातचीत हो गई है। विवेक नाम का उसका आदमी सारा सेटिंग कर लिया है, आप दोनों जाकर फाइनल करो। इसके बाद मैं और त्रिदीप दास उर्फ बाबू कोलकाता में रांची आकर कचहरी रोड में रेसिडेंसी होटल में रुके। विवेक से इंद्रजीत चैटर्जी के माध्यम से कॉन्फ्रेंस से बात हुई। वे मुझे झारखंड टूरिज्म के ऑफिस के सामने बुलाया। उसके बाद मैं विवेक से मिला और विवेक के साथ झारखंड टूरिज्म का ऑफिस गए। ऑफिस में गिरिजा प्रसाद सिंह अकाउंटेंट सचिन सच से मिले, उनसे बात हुई। गिरिजा प्रसाद सिंह 2% कमीशन पर अपने विभाग का रुपया कैनरा बैंक के उपरोक्त फर्जी खाता में जमा करने का वादा किया। गिरिजा प्रसाद से जब हम सब टूरिज्म विभाग का पैसा कैनरा बैंक में ट्रांसफर करने के लिए कहने लगे, तब वह विभाग की प्रक्रिया की बात कर लंबा खींचने लगा। अंततः माह अक्टूबर 2023 को लगभग 10 करोड़ रुपया झारखंड टूरिज्म विभाग का गिरिजा प्रसाद सिंह के सहयोग से कैनरा बैंक के फर्जी खाता संख्या 5910 में ट्रांसफर हुआ। पैसा ट्रांसफर होते ही इंद्रजीत चैटर्जी एवं त्रिदीप दास के कथनानुसार मैंने सिक्योरा इंफ्रा, बंगाल ट्रेडर्स, एचडी इंटरप्राइजेस, विनायक इंटरप्राइजेस, सच एंड सच इत्यादि कंपनी में हवाला कारोबारी के माध्यम से आरटीजीएस किया। हवाला कारोबारी वाला 8 से 10% कमीशन काटकर श्रवण कुमार शर्मा जो बिहार का रहने वाला है, वर्तमान में 2 नंबर राजा देवेंद्र
I've seen, I can make out what is the allegation.
my lords.
इसके अलावा क्या?
And my lords, he states, my lords, the starting line, my lords, that वर्ष 2021 में सबसे पहले फर्जी सीबीआई बनाकर लूटपाट करने के केस में गिरफ्तार होकर कोलकाता लाल बाजार थाना से प्रेसिडेंसी जेल कोलकाता भेजा गया था. So he had criminal antecedents also, and he was used to, my lords, he was accustomed, my lords, to doing such kind of crimes, my lords. And the petitioner before your lordship has hashed the conspiracy. My lords, after Indrajit Chatterjee, the co-accused, my lords, caused the petitioner to visit the said,
No,
my lords, Arnav Ganguly.
apart from these statements,
My
what other things have you done?
Lords, money trail तो नहीं है.
मनी ट्रेल तो नहीं है. होटल गए थे पता करने, रुका था कि नहीं? मनी ट्रेल तो नहीं है. होटल गए थे पता करने के लिए, रुका था कि नहीं? इन्वेस्टिगेशन तो अभी चल रहा होगा. इनको नोटिस किया आपने अपीयर करने के लिए? इनको अपीयर करा देते हैं आप?
My lords,
कर दीजिए.
my lords, my
बताइए इनका कोई नॉन कोऑपरेशन है, कोई नोटिस किए हैं, क्या किए हैं आपने?
That's 409 is there, 467 is
कोई
there.
बात
my lords. That's 41 it will not be attempted.
That's right, it is not effective. But the point is you want to interrogate me, no?
Yes.
You interrogate me. क्योंकि अभी तक तो कुछ नहीं आया. कुछ मटेरियल ले आए. आपको बता भी दिए. इनका I can understand money trail नहीं मिल रहा. रुके थे, आए थे, रुके थे, गए थे. होटल का बात कर रहे हैं, मीटिंग का बात कर रहे हैं.
There is no investigation on that.
वो तो आपको करना ही नहीं है ना. सिर्फ एफआईआर करके हम लोग को तंग करना. या आईओ को हम लोग बताएंगे कहाँ कहाँ इन्वेस्टिगेशन करना है. सीसीटीवी फुटेज सब जगह मिलेगा आपको जो जो आपको चाहिए.
My
As of now, there is no material against him. 409 खाली बोलने से थोड़ी होगा. क्या चीज है 409? You have no material against him. बताइए कब भेज देंगे इनको आप? आप कर लीजिए इनको जितना इन्फॉर्मेशन.
I know that whatever date litigation fixes, I will be there.
चलिए आप कर लीजिए.
first week of July will be approved.
ठीक है.
Yes, please. I know here.
For the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that although in the FIR there is an allegation that by opening forged bank account, money from Jharkhand State Electricity Employees Master Trust was transferred in the bank account, and further money was also transferred from Jharkhand Tourism Development Nigam Limited. It says that the petitioner is neither the employee of the bank nor he is any employee of the state. He is totally correlated with the entire transaction. He submits that he has no role in opening the bank account, nor he has any role in siphoning off the money. He submits that except confession statement of the accused, there is no material pointed out by the learned counsel for the opposite party against the petitioner.
And self-confession is another.
And further, the opposite party have also relied upon confessional statement of the petitioner in another case. He has submitted that the petitioner is ready to cooperate if some interim protection is granted by this court. He shall appear before the authorities and get a statement accordingly. And further course can be decided depending upon the materials collected during investigation. The learned counsel for the opposite party submits that investigation is going on, but during the course of argument, apart from the confessional statement of the accused and the confessional statement of the petitioner in another case, no material could be pointed out by the learned counsel for the opposite party against the petitioner. However, he submits that the present case is an anticipatory bail, and if the petitioner is taken into custody, then he may be examined. After hearing the learned counsel for the parties and considering their posted submissions, this court is of the view that, as on date, apart from confessional statement of accused, no material has been pointed out by the learned counsel for the opposite party. In such circumstances, the purpose of both the parties will be served if the petitioner appears before the investigating officer of the case and some interim protection is granted. To this, the counsel for the opposite party has submitted that the petitioner may appear on 1st of July.
My lords.
The petitioner is directed to appear on 1st of July in the office of ACB.
My lords.
ACB Ranchi.
Yes.
ACB Ranchi at 11 a.m. and continue to appear before the authority as and when the date is fixed. The petitioner shall also furnish his email ID. The petitioner shall also furnish his email ID to the authority so that the date and time for appearance of the petitioner is duly communicated from time to time. Post this case on कितना दिन बाद रख दें बताइए?
Lords, I stand corrected, my lords. Lords, the appropriate agency will be the CID. Lords.
CID,
Yes.
ACB Ranchi, CID Ranchi.
My lords.
कहाँ है इनका ऑफिस? CID Ranchi
Lords,
कहाँ पर है? नहीं पता, नहीं पता.
hardly they come, my lords. It may not be recorded.
नहीं, I am not recording. I am just indicating कहाँ जाना है. He must know ना where he has to go. आपको पता है कि सीआईडी रांची कौन सी?
रांची एसएसपी जो रेजिडेंशियल ऑफिस है ना उसके बाद
रांची एसएसपी के रेजिडेंशियल ऑफिस के बगल में
Usai colony.
किसाई कॉलोनी
My
नहीं, कचहरी में
रेडियम हमारा बात जानने वाले
ठीक है, रेडियम रोड. कितने दिन बाद रखने बताइए? When should I put it?
Second week of July.
First week of July 1 तारीख को, second week of July तक आपका हो जाएगा काम.
इनका appearance का है and thereafter.
Appearance के बाद आपको you continue with this. आपको उसके बाद कम से कम 2-3 बार तो इनको बुलाएंगे. I do not know.
First week of August. Last week of July.
हाँ, 31st July को रख देते हैं. Post this case on 31st of July 2026. In the meantime, no coercive steps be taken against the petitioner if the petitioner cooperates with the investigation and appears before the authority on each date and time as may be fixed by the authority. In case of even one default, it will be open to the authority to take all coercive steps against the petitioner.
Report one thing that if there is a requirement of subsequent appearance, notice may be given on same day so that there will be no.
आपका email ID देने के लिए बोलिए। मेल अपना देखते रहिए। कहाँ से आए? कहाँ के हैं? हाँ? कोलकाता. The dates for appearance should be intimated to the petitioner at least 2 days in advance.
Yes.
Orders will differ from daily item 1, BA file number 26798 of 2025.
Yes, petitioner.
Relationship, there are two remaining defects. They just need to ignore the
Which, which defect?
that defect number must be 89.
89.
Number. One is that free copy of improved order or CC or improved order with proper AF may be filed. That I have already.
Defect 89.2 and 89.5.
Yes, what is those are already in the sealed envelope relationship because this relates to POCSO Act. So I have already done that relation. One is the copy of the FIR and another is the certified copy of the improved order.
Free copy of the improved order or CC of the improved order with proper. You have filed it in seal cover.
Yes.
Okay. And what else?
And other is the copy of the FIR. That is also there in the seal.
Some pages are missing.
That is already there in literature.
Which page number?
Page number 62, page number 10.
6 to 10. You see page number 10 and where is page number 11? It is in continuity.
It is only for
Page number 10. You come to page number 10.
this.
Read the last sentence.
अतः श्रीमान निवेदन है कि जांच करते हुए सभी व्यक्तियों के ऊपर कानूनी कार्रवाई
कहाँ लिखा है? ऐसा तो नहीं है.
Your leadership, that is there in the seal cover because the details of the victim was supposed to be eradicated and thereafter it was supposed to be filed in the seal cover. So that is there in the seal cover.
The learned counsel for the petition submits that the surviving defects may be ignored. In view of the fact that certified copy of the improved order has been filed in the sealed cover, and so far as the further defect regarding missing page of FIR is concerned, the last page at page number last page of the FIR annexed with the bail application at page number 10 appears to be incomplete because of the reason that the name was required to be omitted. The photocopy which has been filed in sealed cover is the complete FIR. Considering the aforesaid submissions, the defect as pointed out by the office is hereby ignored. Is what is it you want to argue? You want to-
The leadership offense is that this accused person assaulted the victim, and the leadership there is no medical report, and the leadership
Counsel for the state. What is the stage of the case?
it is at evidence stages.
How many witnesses have been examined? This is a very old order. So what happened thereafter? Yeah. And this bail application is also quite old. Since 24/11/25, it has remained pending.
This has come from legal aid leadership.
Counsel for the state. Is directed to serve notice upon the informant and file a counter affidavit in this case. Date the case diary. We call for from the concerned court along with the statement of the victim recorded under section 183 PNSS and medical examination of the victim. The stage of the case we also intimated to this. Office is directed to file a number होगा इसका file registration order करना हो जाएगा. Post on 14th of July. The counter affidavit should be filed latest by 13th. State.
Yes,
13 तारीख को counter file.
For second two, BA file number 10582 of 2026.
ISB file for voting defect number 1.
What is defect number 1?
Sections of urgent sections mentioned in the FIR and include not a difference.
The learned counsel for the petitioner is present, parties are present. I number 727/26 has been filed seeking ignoring the defect number 1. Otherwise, the FIR number, everything is same.
Yes, ma'am. Sections of the POCSO Act.
Any objection? The learned counsel for the state has no objection so far as I use ignoring the defect number 1 is concerned. Considering the submissions, IBA number 7327/26 is allowed. The defect number 1, as pointed out by the office, is para 1 में कौन सा sections लिखे हैं? FIR का sections लिखे हैं कि कौन सा?
FIR.
You have written FIR sections, no? Okay, that's- is ignored and the learned counsel for the petitioner is directed to make necessary is permitted to make necessary correction in para 1 and pair of the bail application in consonance with the sections mentioned in the FIR during the course of the FIR is a type of post this case on next one.
Item 3, BA file number 111500/1026.
Effective terminals. The bail petition of Govind Kumar has been filed terminals. Kindly see page 24, that is the impugn order.
You have filed IA
Yes,
for ignoring
for
the
ignoring defects.
defect is what is the defect?
Defect terminals, instead of mentioning Mr. Govind Kumar in the impugn order, in the concluding part of the impugn order, Lala Kumar, the co-accused name has been mentioned. In the top of the impugn order, the correctly been mentioned minutes. In the concluding part minutes, Lala Kumar has been mentioned minutes. So that may be ignored. Page 24.
No, Dala.
Page 24.
That's it.
Top Govind Kumar is mentioned in the first
So
paragraph.
this is the application of Govind Kumar.
Yes.
The learned counsel for the petitioner submits that. That is the sole least surviving defect.
Yes.
IA number 7376 of 23 has been filed for ignoring the defect number 1 as pointed out by the office. He submits that in the improved order at the first page, the name of the accused Govind Kumar has been mentioned, but at the last page, the bail application of Lala Kumar is said to have been rejected. That means that it is evident that the bail application of Govind Kumar was under consideration before the court. Counsel for the state has no objection to the prayer for ignoring the aforesaid defect. Accordingly, ID number 7376 of 26 is hereby allowed. The aforesaid defect is ignored. What else? Okay. Pose this case on next one. That.
Item 4, BA file number 11983 of 2026.
Filed in IM minutes for ignoring of defect minutes. Defect has been pointed out that minutes regarding the enclosures minutes. That is at page 14, running page 14 minutes. In a Tariq Yapam.
Why have you not filed yours?
The entire set of FIR which has been provided by the land court below minutes has been filed under that does not contain the enclosure minutes. Some of the pages are there minutes, some of the pages are missing. Page 14. गिरफ्तारी ज्ञापन की मूल प्रतियां 4.
Learned counsel for the petitioner has submitted that the interrogatory application has been filed for ignoring a defect. With respect to filing of enclosures to the FIR, he submits that whatever was provided by the learning court has been filed, and the enclosure to the FIR was not given along with the certified copy. The learned counsel for the state has no serious objection so far as ignoring the defect is concerned. Considering the aforesaid submission, IA number 7404 of 2026, ignoring the is allowed, and the defect regarding filing of enclosures to the certified copy is ignored for the present. What is the matter? Can be withdrawn.
Withdrawn. Charge is in front. Okay.
The case has been acted on where the learned counsel of the state is directed to file a counter affidavit in this case along with the criminal antecedent report of the petitioner. Taking into consideration as to whether any criminal case has been registered against the petitioner in the state of Jharkhand or in any other state. In view of the complaints which might have been registered in the portal. The counsel for the state shall also file the FIR with its enclosures. File the enclosures. Okay, along with the counter. Case diary concern. Where is the case pending?
Jamtada.
Jamtada.
Yes.
Let the case diary. Case diary के enclosures में तो हो गई सब कुछ है ना? आप छोड़ दीजिए हम case diary बना दें. Let the case diary along with its enclosure be called for from the concern. आपके और cases हैं?
लॉर्डशिप इसमें कंसर्न एपीटी का बीमार है तो हम चाह रहे थे कि
आपके कंसर्न एपीटी का नाम लिखाना पाएंगे आप
नहीं मेरा नाम ही हो बट ये कॉलेज में भी मेरा नाम
ऐसा नहीं
so that कि ये लिख सके हो
तो कौन कहाँ बीमार थे
सुनील दुबे है इसमें जो अभी रिम्स में भर्ती है तो थोड़ा सीरियस
अच्छा इन्हीं का नाम है The counsel for the state, Mr. So and so, is directed to seek instructions and contact. At his request, office is directed to print the name of the name in the cause list. From the side of the office. Date concert in the pen. 21st July. The counter should be filed by 28th October. ये case number कितना है? Jamtada case number
6725. 67 of the 25.
67 इसका डेट 21st को रखते हैं ना.
Item 5 BA file number 12920 of 2026.
Lordship, I am praying for simply withdraw this case, Your Lordship. With the verdict, I appeal in this case.
Appeal.
Yes, Lordship. Offences related to human trafficking, which comes under criminal offences.
Appeal is maintainable. Yes. Appeal is maintainable.
Yes, but this is a BA file.
The counsel for the petition submits that the
Schedule.
present
Schedule.
bail application is not maintainable. He submits that he may be permitted to withdraw this case with the liberty to file appeal.
Matter
Says
related
that
to human trafficking, Your Lordship, which comes under the schedule offences. Your Lordship.
so appeal is maintainable.
Yes,
Considering the submissions, this bail application is dismissed as withdrawn. Liberty is reserved to the petitioner to take steps as per.
Your Lordship, one more prayer. Certified copy of the SB order and
Sign कर दीजिए sign कर दीजिए. Court case filing item 6 BA 5087 of 2026.
The case of cybercrime only withdrawn by Lordship has remained in custody for almost 9 months and charge has been filed.
Charge payment by
Charge has been filed on 7th of May 2026. And a certified copy of this
antecedent.
is one antecedent on that ground only Lordship has been. But has remained in custody for 9 months.
When was charged?
Charged by on 7/5/2026.
That is the date. When, since when are you in custody?
Since 29/9/2025.
29/9?
2025. This is charged by me.
What is the allegation against
Only
you?
that cyber एक victim था.
Only one victim?
Only
has
one
been
victim.
From where do I get this?
She has called for that.
Not yet. Counsel for the state is directed to file a contract claim in this case, along with the criminal antecedents of the petitioner. बाकी जो रहता है पोर्टल में देखने कंप्लीट. Office is directed to call for the case diary from the consultant. With all its implications and also the stage of the case. Post on 21st of July, contract which should be filed latest by 20th of July.
The Ceylon overall had with
ये कौन सा serial
ये तो
number?
sin 6 पर
Same
नहीं
order.
12 अलग केस
इसके साथ tag कर.
इसके साथ अलग केस
इसके साथ tag कर. Why are you mentioning 12? हाँ?
it's a case of 7.
तो आपको क्या लग रहा है कि अभी सारा जितना क्लासेस कॉल केस फॉलो अप होने का वेट करिए. Is it not too much?
Item 7, BA 5090 of 2026.
Yes.
Lordship, allegation about the petitioner is that sexual physical relationship was established on the pretext of marriage. But Lordship, there are few grounds on which this doesn't stand. As because the petitioner was at the place where it is said to have been committed the offence, he was not there present, and he was kind of outside the state also. He was posted in Bihar Ministry Consultancy Services, in which we have also filed a attendance sheet. And there's a Lordship medical report which doesn't support.
The counsel for the state is directed to serve notice upon the informant of the case and also file the counter affidavit in this case.
It's in custody from last 2 months.
You have been absconding.
No, yes. No.
Lordship, in this matter,
Take the case diary along with its enclosure with the statement of the victim recorded under section 183 BNSS and a medical examination report if any be called for from the concerned court. तो FSI है.
No, FSR, Lordship, the case direct has no. It doesn't support. I mean, independent witnesses are also there too. He who has stated that he was not present.
We'll see the case diary. The counter affidavit will be filed by 20th of July, post on 21st.
Item 8, BA 5091 of 2026.
My lord, initially FIR was registered under section 64(1) and 69 BNS, but charge sheet was submitted under section 64(2)F. Page 19 is the FIR. May I read it, my lord?
Just a moment.
Victim is
Trial is going on.
yes, my lord. Two of witnesses were examined. The petitioner is custody since 6/9/25, and only 2 witnesses were only examined. My lord.
We will expedite.
And as per their statement, my lord, no case is moved out under section 69 or 64(1), my lord.
2 witnesses have been examined, right? Victim
Yes.
has been examined.
No, till that
Victim has
no.
not.
Whenever permit me to read the FIR, my lord.
We'll expedite your trial.
ऑफेंस मेड आउट ही नहीं हो रहा, मतलब हम एफआईआर पढ़ के ही माइनर को पहला पैराग्राफ ही समझ में आ जाएगा कि केस मेड आउट नहीं हो रहा है।
पढ़ी।
मेरा सविनय निवेदन पूर्वक कहना है कि मैं लक्ष्मी सोरेन एज 23 वर्ष पिता सत्यन से गांव सत्यन से बड़ा कुर्सी थाना गालूडी जिला पूर्वी सिंहभूम झारखंड के रहने वाले हूँ। मैं और मेरे साथ रमेश खातू जो पिता सत्यन सर गांव सत्यन सर रहने वाला है, जो वर्तमान में मामा घर गांव सत्यन सर में रहता है। गांव के बगल में सिंदरडांगा जंगल में गाय चराने जाता था। इसी क्रम में हम दोनों के बीच प्रेम प्रसंग एवं शारीरिक संबंध होने लगा, और जिससे मैं गर्भवती हो गई। गर्भवती होने के उपरांत रमेश टुडू से बात किए तो बोले कि कोई दिक्कत नहीं, हम शादी कर लेंगे। प्रॉमिस ऑफ मैरिज जो हमारे को आफ्टर हो रहा है, पहले प्रेम संबंध पर इट्स ए केस ऑफ म्यूचुअल कंसेंट माय लॉर्ड। और दो इंडिपेंडेंट विटनेस जिन लोगों का गवाही हुआ है उन लोग भी यही बात बोल रहे हैं कि विक्टिम बताई कि प्रेम प्रसंग इन लोगों के बीच चल रहा था। देयर इज नो यूज ऑफ एनी क्रिमिनल फोर्स और एनी नथिंग मैन। T.19.06 का पैराग्राफ 3 देख लीजिए एक बार, जिनके हाथों से एफआईआर लिखा गया है। T.W. खुद विक्टिम की मदर है, उनका भी पैराग्राफ 3 एक बार देख लीजिए। दोनों एलिस्ट सेक्शन जो है दोनों ही में डॉट नहीं हो रहा है।
On false pretext of marriage पर केस नहीं हो सकता।
नहीं, शुरू तो नहीं है, शुरू में बोल रहे हैं कि प्रेम प्रसंग हुआ, शारीरिक संबंध बना, जब गर्भवती हो गई तब हम फॉर्म मैरिज का प्रीटेक्स्ट दिए हैं। शुरू में वो बात कहाँ बोल रही है, वही हम बताना चाह रहे थे।
वॉशिंग नहीं बहस कर रहे ना।
9 महीना कस्टडी हो गया।
Heard the learned counsel appealing on behalf of the parties.
प्रीवियसली सिमिलर एक मैटर में हुजूर बेल दिए हुए इसी तरह के केस में, कि दूसरे केस में
हम बेल
इसको देख लिया।
विक्टिम नहीं एग्जामिन।
नहीं, इसमें हुजूर विक्टिम जो है सुसाइड कर ली थी, उसमें हुजूर बेल दिए हुए हैं, एक बार देख लिया था ऑर्डर को।
ऐसा तो हम सुने हैं कि कोई एक्यूज का बेल के साथ कंपैरिजन होता है, लेकिन ऐसा नहीं सुने हैं कि दूसरा केस में किसी को बेल दिया है उसके साथ
सिमिलर नेचर का तो हुजूर खोज रहे थे कि मालूम है कुछ सिमिलर।
आज तक दो आदमी पर सिमिलर नहीं हुआ और दो केस सिमिलर नहीं।
बिल्कुल नहीं।
क्रिमिनल प्रैक्टिशनर है, हमसे पूछिए।
एलिगेशन एटलीस्ट सेम।
There are no two identical cases so far.
नहीं हो सकता है।
कोई बात। Heard the learned counsel appealing on behalf of the parties. The counsel for the petitioner submits that the petitioner is in custody since 6/9/2025, and the petitioner has been falsely implicated in this case. He submits that on the case of the FIR itself, it appears that there was love relationship between the victim and the petitioner, and subsequently she became pregnant. And thereafter, she alleged that the petitioner has committed rape upon her in false pretext of marriage. The learned counsel has submitted that no case is made out against the petitioner. The learned counsel for the state has opposed the prayer for bail. He has submitted that as per the impute order, trial is going on. And out of 8 charge sheeted witnesses, 2 witnesses have been examined. At this, the learned counsel for the petitioner, at this upon the query of this court, the learned counsel for the petitioner has submitted that the victim has not been examined so far. After hearing the learned counsel for the parties and considering the fact that trial is going on and the victim has not yet been examined by the court so far, this court is not inclined to enlarge the petitioner on bail. However, it further appears that after investigation, charge has been framed for offence under section 64(2)(m) of DNS, in alternative under section 69 of DNS. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the director of prosecution and also to the SP of the consultants.
Item 9, PA 5092 of 2026.
Because relate to cybercrime, This is the first time it has come, but co-accused has been granted bail. And the station 13/1/2026 charge has been formed. There is no antecedent. There is no antecedent. And
The learned counsel further state is directed to file a counter affidavit with the criminal antecedent report of the petitioner, clearly indicating as to whether any other case has been registered against the petitioner in the state of Jharkhand or in any other state, and taking into consideration the complaints which might have been registered in the which might has been mentioned in the.
एक है
अभी कितना है कहीं बताओ.
जी हम डायरी से बोल रहे हैं.
आप महान है, आपके पास डायरी ना मेरे पास है ना उनके पास.
नहीं, हम महान नहीं, हम चार्ज फ्रेम हो गया है, इसीलिए पेपर सप्लाई हो गया है.
आपका डॉक्यूमेंट नहीं देख सकते. Let the case diary along with its enclosure be called for from the concerned court. The counter affidavit be filed with the stage of the case. Counter affidavit be filed by 20th of July, post on 21st.
कोई कुछ का बिल
20 जुलाई शॉर्ट ही है, ज्यादा लंबा डेट.
एक महीना.
ठीक है, 14th को रखते हैं, 13 तारीख तक है. क्या फाइल रिसीव हो गई. उसके बाद नेक्स्ट केस कॉल करके उसको खोल. You just have to wait for some.
Item 11. BA 5099 of 2026.
It's a case of cybercrime. Petitioner has no criminal antecedent, but is a truck driver. His bank account has been used as a mule account by the cyber thugsman. The allegation is that one link was sent in the WhatsApp of the informant. When he clicked the link, 19,85,073 rupees has been deducted.
It came to your account.
No, not entire amount, part proceeds of the crime. That is rupees 1,95,000. That has come.
And you withdrew that amount to credit card.
I have not used that amount. That is still in my account, that has been freezed.
Right.
I am ready to return that amount. I have no criminal antecedent.
Yes, state.
He is the beneficiary. In his account 1,95,000.
Any antecedent? Any antecedent?
I've just received diary notice.
Diary में नहीं है antecedent.
Diary में antecedent.
I have given statement to that effect. My father is on.
कब से custody?
18 March 26.
18/3.
26.
Charge
Charge sheet has been submitted. Charge sheet has been submitted on 12th June.
आपके पास क्या है डायरी? चार्ज शीट हो गया as per डायरी. एंटीसीडेंट बताइए. नहीं है तो आपको दीजिए. नहीं समझ आ रहा. कितने का डायरी?
एंटीसीडेंट नहीं.
अभी आपको मिला, आपको क्या ही पता है. दीजिए डायरी आने.
एंटीसीडेंट नहीं आया.
ये FIR नंबर कितना है?
141.
सागर कुमार यादव, राइट? ये नाम है ना इनका?
सागर कुमार.
रिलेवेंट पारा जो है इसका क्या इसको फोल्ड कर
साइबर केस नंबर पड़ गया 47 और 26.
What's the learning council's opinion on behalf of the parties? The learning council for the petitioner submits that the petitioner was so criminal antecedent and he has been falsely implicated in this case. He has further submitted that the victim has been that the petitioner, there is confession statement of the petitioner wherein he confessed that along with 4 accused persons he cheated about the accused petitioner had confessed that he along with 4 accused persons cheated near about 19 lakhs and he received rupees 1,95,000 through credit card from the aforesaid amount. The learned counsel for the petitioner submits that only 1,95,000 is alleged to have been recovered he is alleged to have been found in his account and the account has been frozen. The learning council for the state has opposed the prayer for bail. After hearing the learning council for the parties, it appears that the case is a case of organized crime and proceeds of the crime has been found in the account of the petitioner. Accordingly, this court is not inclined to allow the petitioner on bail.
Item 12, DA 5100 of 2026.
The Roshi just fixed one to accuse bail on 1st of July. DA number 5031 of 2026.
What is the date?
1st of July 2026.
At the request of the counsel for the petitioner, close this case on 1st of July 2026 along with BA number 5031 of 2026. To which counter affidavit has already been filed. Case diary.
Case diary.
The learned counsel for the state is directed to seek instructions and file a counter affidavit in this case. वो जो standard है हम लोग का सारा पोर्टल देख कर मैडम पोर्टल देख के फाइल करिएगा काउंटर.
Item 13, BA 5102 of 2026.
This petition.
The case has been registered under section 292 and 293, also under the POCSO Act. But which relates to the public nuisance. Public nuisance. A raid was conducted in some hotels, and it was found that without proper their identity, they were allowed to provide. And some girls and boys were found in the.
Who are you?
This petitioner is also named, and he was found with one of his relatives in the hotel.
SC/ST Act भी है इसमें.
If I to understand, after going through the FIR, there is no victim alerts, and none have made any complaint, and there is no such allegation. The offence was committed.
The case has been registered under section 325 of SC/ST Act.
Yes, ma'am. That's also been registered. But from plain reading of the first information.
No, I do not know. Once the case is registered under SC/ST Act.
Bail is not eligible. Bail is, but it will not be appealed because other sections are also there.
No.
Yes, ma'am. Literally Monday, matter has been earlier raised before this honorable court and decided matters. In case of object and also the bail will be applicable, not the.
There is some order.
Yes, ma'am. I will verify also. Other accused persons have been granted bail. The only allegations that they were allowed to enter, they were allowed to stay in the hotel without proper verification. So on that basis, the suspicion has been registered. First information report has been lodged against several persons. This is the main information. Apart from that, there is no such information. That this prisoner has committed any wrong with any female. There is no such information. Understand? So,
Yes,
please.
SC/ST Act is also there. Bail is applicable. Bail is maintainable. Or criminal appeal would lie.
No defect has been pointed out by the office also. We are regularly filing the bail applications. Apart from the SC/ST, other sections are also there.
Defect. ये स्टैम्प रिपोर्टर को जरा बुलाइए तो पता करिए आप रुक जाइए बिल जरा फाइंड करिए इसमें बेल होगा कि अपनी
1 बजे इसको
तो पता करिए
recently bail has been granted. So this
must have been but we need to find it out जहाँ तक हमको लगता है SC/ST Act इंक्लूड होने से नॉर्मली तो
because the other sections are also there Maharaj.
SC/ST Act के साथ तो हर अदर सेक्शन लगेगा ही ना
इसमें जजमेंट है उसको हम देख सकते हैं
कोई बात नहीं आप जजमेंट लेके आइए
Item 10.
Item 10, state is there?
Item 10, BA 5096 of 2026.
Are you there for the state? Yes, please.
Section 64 section 6 of sorry.
Allegation FIR पढ़िए आप क्या stage है बताइए?
Stage में charge sheet has been submitted, but victim was not cited as a witness. It appears from the intimate order.
So she cannot be examined in trial, merely because she is not there as a
No,
witness.
161 CR.
आप हमको बताइए, अगर victim, she cannot be examined in the court. ये चार्ज शीट witness के अलावा भी तो examination victim का हो ही सकता है ना?
होता है।
तो ये कोई ground नहीं है।
इसका स्टेटमेंट नहीं है।
कोई बात नहीं। आप FIR पढ़िए।
FIR is at page 21.
पढ़िए। नाम मत पढ़िए ना। Do not read the names.
हाँ। विषय FIR has been instituted by mother of the victim. मेरी नाबालिग पुत्री डरा धमकाकर एवं शादी का प्रलोभन देकर यौन शोषण करने और सामाजिक रूप से बदनाम करने तथा अंजाम भुगतने की धमकी देने के संबंध में निवेदन पूर्वक कहना है कि मैं सचिंसर निवासी हूँ। मेरी एक भतीजी की शादी ग्राम चितरगढ़िया सिकारीपाड़ा में हुई है, जो हमारे पारिवारिक सदस्यों का आना जाना है। वहीं पर मेरी बेटी पुत्री करिश्मा को चितरगढ़िया निवासी सचिन सर को देखा और उसका पीछा करने लगा। मेरी बेटी उनका पोखरा चौक के मंदिर के पीछे स्थित मानव मंडल के मकान में भाड़ा में रहकर पढ़ाई कर रही है। मेरी बेटी के रूम में जाने लगा और मार्केट ट्यूशन आने जाने पीछा करने लगा। फोन पर प्यार करने और शादी करने की बात करने लगा और न मानने पर बदनाम करने और बलात्कार करने की धमकी देने लगा। इसी क्रम में एक बार अंसारी ने जबरदस्ती करिश्मा को अपनी मोटरसाइकिल में शिकारीपाड़ा के मिनी दार्जिलिंग ले गया और वहाँ जबरदस्ती शारीरिक संबंध बनाया। इसके बाद वो अक्सर करिश्मा को ब्लैकमेल और धमकी देकर बुलाने लगा। करिश्मा खातून को लेकर अक्सर रसीदपुर स्थित अपने एक दोस्त के रूप में यही नहीं कि सेल्फी ब्रिज के में जाकर भी शारीरिक संबंध बनाया। 13/11/2025 को शिकारीपाड़ा थाना क्षेत्र के पास पहाड़ी में लगने वाले रास मेला में भी मोटरसाइकिल से ले जाकर शारीरिक संबंध बनाया। हमें इस संबंध में जब अत्र तत्र से जानकारी हुई तो पूछने पर बताया कि जान मारने की धमकी देकर जबरदस्ती बुलाकर यौन शोषण करता था।
और the learned counsel appearing on behalf of the petitioner. The council submits that the petitioner is in custody since 16/1/2026 and charge sheet has been submitted, but victim has not been cited as a witness. The learned counsel for the state has opposed the bail for him. After hearing the learned counsel for the parties, this court finds that there is specific and direct allegation made against the petitioner. And the statement of the victim has been also recorded under section 183 BNSS by the court concerned. And she was minor on the date of alleged occurrence, which is also mentioned in the interim order based on school admission register. Considering the nature of allegation, this court is not inclined to enlarge the issue on the institute. Sorry? क्या say आपको?
बोलने नहीं पाया सिर्फ इस एक दो लाइन मेरा सबमिशन लिखा है that the FR date of occurrence is alleged to mention in the FR number 87/2025 and she went several places and the FR had been instituted on 15/1/2026 by victim and victim mother himself said अतर से खबर मिली और इसमें यह है कि एज जो है मेडिकल रिपोर्ट में 18 साल
It submission the learned counsel for the petitioner has submitted that the alleged date of incident is 8/7/2025 and the petition and the victim had moved with the petitioner from time to time and the FIR has been lodged on 15/1/2026 by the mother of the
mother of the victim.
Item 14 BA
School
51
register आ गया सर और कुछ नहीं चाहिए.
Item 14 BA 5107 of 2026.
Yes, petitioner.
My lords, in custody since 24th of April 2024.
24/4/24. What is the stage of the case?
4 witnesses, 5 witnesses have been examined. my lords.
5 out of
7. Doctor has not been examined and another witness.
expedite the case.
My lords,
Trial expedite the case.
एक बार
कौन सा date है next date बताइए.
next date है वो 27th of July 2026.
आ जाएगा ना witness उस दिन.
अभी तो FSL भी नहीं आया है.
मंगा लेते हैं.
हाँ वो मंगवा लिया जाए और एक बार चार्जशीट का पेज नंबर पेज नंबर 22 एक बार petition. The second para end it is clear that nothing is
Sorry.
is in charge sheet it has come like this. Victim का जो investigation हुआ है जो medical जांच हुई है कुछ पाया नहीं होगा. दूसरी चीज है ये कि जो
पाया नहीं गया मतलब
तो कहीं कुछ हुआ ही नहीं. कहीं कुछ नहीं हुआ. ये तो इसमें है जो अगर बोले परमिशन दे तो हम पढ़ भी देते हैं. और जो विटनेसेस हैं उनके भी क्रॉस एग्जामिनेशन में सारी चीजें आई हुई हैं. जो एफआईआर लॉन्च हुआ है
victim examine हो गई है.
विक्टिम एग्जामिन हो
He has supported or not supported?
वही तो डिफरेंसेस है. मैंने 164 सीडब्ल्यूसी का बयान 161 का बयान और अभी जो एग्जामिनेशन हुआ है चारों चीजें अलग अलग हैं. दैट इज माय
For the learned counsel appearing on behalf of the parties, the learned counsel for the petition submits that the petition is in custody since 24/4/2024 and 5 out of 7 witnesses have been examined and the next date in the case is 27/7/2026. He submits that the FSL report has also
No, it has not been received.
has not been received by the learned tribe so far. He submits that there are material contradictions in the evidence so far recorded the victim has been recorded, but she has supported the prosecution case, but there is variance in her statements. आपको क्या बोलना है?
उनको यही बोलना है कि she has supported the case of prosecution. All
The
the
counsel for the state has submitted that the victim has
all the
supported
witnesses.
all the witnesses have supported the case of the prosecution.
1 to 5. I will.
After hearing the learned counsel for the parties, this court finds that none of the counsels have pointed out that the case of the petitioner was bail application of the petitioner was rejected
Earlier. Previously it was
earlier
rejected.
on 7/12/2024 in VA number 10271 of 2024.
In second paragraph I have mentioned.
आपको अभी समझ नहीं आ रही है बात क्या है? इतना बाद में क्या बात चल रहा है? पहले बोलेंगे कि पहले बोलेंगे नहीं, उसके बाद बोलेंगे कोर्ट नहीं रिकॉर्ड करता है,
माफी मांगते हैं। ऐसा कोई
और स्टेट भी वैसा ही है।
स्टेट तो नहीं बता सकते हैं तो पहले है।
कभी कभी लगता है स्टेट और पिटिशनर साथ ही साथ चल रहे हैं।
ना वैसी बात नहीं है।
तो फिर कैसी बात?
Earlier
अभी 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 इतना कहानी हुआ, अर्ली रिजेक्टेड का कहानी कौन बोलेगा? आप लोग का ड्यूटी नहीं है बोलने का, कोर्ट चेक कर।
rejected it.
आप कहाँ सबमिशन किए कि अर्ली रिजेक्टेड? Did you make the submission? You did? You did not make that submission. वीडियो दिखाएं, आपका सबमिशन नहीं था कि अर्ली रिजेक्टेड, इसीलिए आपको मौका दिए थे, लेकिन आप तो बोले ही नहीं, आपको कोई मतलब ही नहीं। You are not bothered.
Everything is written here.
Written मतलब क्या? Written तो सब चीज रहता है। Argument नहीं करेंगे। Is it not your duty to point out? Petitioner तो नहीं point out करें। जब सबसे ओपनिंग सेंटेंस इनका यही होना चाहिए। फिर बोलेंगे कोर्ट नहीं रिकॉर्ड करता है हम लोग का सबमिशन। कौन मानेगा आपको का बात? Considering the fact that the bail application of the petitioner was rejected earlier, and 5 out of 7 witnesses have already been examined, this court is not inclined to, and the serious nature of allegation against the petitioner, whereby it is alleged that the petitioner had established physical relationship with minor daughter of the informant aged about 14 years. This court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly reviewed before the court, and the FSL report is also forwarded to the trial court at the earliest. The learned counsel for the state is directed to communicate this order to the SP of the concerned district and also to the Director of Prosecution and to FSL branch.
Item 15 BA 5114 of 2026.
So this is regular date for the hospital 103.
Who are you?
I'm the husband.
Date of marriage?
Marriage was April 2015.
Date of occurrence?
Date of occurrence 1/4/2026.
Cause of death?
Hanging. Hanging as per postmortem.
Hanging मतलब?
फांसी लगा. Hanging.
अच्छा hanging. तुमको लगा hanging.
Hanging. So,
Hanging. Suicide.
suicide.
Charge sheet submitted on
Justice
suicide.
Central Justice 108. Corresponding 306 of practice.
Found dead at home.
Yes.
Cause of death?
Cause of death, it is being said that the instigation was made to her and she has committed suicide.
FIR.
Page 18. सिविल निवेदन पूर्वक कहना है कि मैं रेखा देवी उम्र 45 साल पति से साहिबगंज की निवासी मेरी पुत्री काजल देवी उम्र 27 साल का विवाह वर्ष 2015 के अप्रैल माह में दिल्ली था। This is a petitioner
हिंदू रीति रिवाज के साथ हुआ था, जिसको शादी के बाद से उसके पति, सास, ससुर एवं देवर मिलकर मेरी बेटी काजल देवी को मायके से पैसे मांग कर लाने के लिए मारपीट कर प्रताड़ित करते रहे। इसी बीच 2 बेटी एवं 1 बेटा का जन्म हुआ। इन बच्चों के भरण पोषण के लिए पैसे एवं आर्थिक सहायता का दबाव हमेशा दिया जाता था तथा यह पूरा न होने पर मारपीट एवं गाली गलौज करते थे तथा इनके पति के द्वारा आत्महत्या कर लेने के लिए बार-बार मानसिक दबाव दिया जाता। एक माह पूर्व इसके देवर पवन लाल श्रीवास्तव के द्वारा मेरी बेटी को बहुत मारा गया एवं यह कहा गया कि इसे मैं ही मारूंगा एवं पवन लाल श्रीवास्तव के द्वारा यह कहा जाता था कि मेरे भाई अंडर ब्रैकेट दिलीप लाल श्रीवास्तव ने इसे मारने का आदेश दे दिया है एवं दिलीप लाल श्रीवास्तव के द्वारा भी उन पर मर जाने के लिए दबाव डाला जाता है, अन्यथा यह खुद उसे मार देगा या मरवा देगा। इससे मुझे खुद विश्वास है कि मेरी बेटी काजल देवी की हत्या इसके देवर
Any anti-mortem injuries apart from
anti-mortem injury is not there. The thing has come, CCTV footage has been taken by the investigating officer. It is found that the petitioner at the time, relevant time, was working in at Ghaziabad, in a jeans factory. He was not present there. Let's make see the MP note also.
just
It has also come in the MP note.
yes, madam, what do you say?
There is a specific allegation against him. He has abetted the work Mr. Pawan Lal Srivastava to commit the to assault the deceased and commit the murder.
I just want to know, is there any injury of assault?
I am not having the case study. So case study is where
Well, when it comes for the state is directed to file a contract to take the case diary along with the postmortem report of the victim and other enclosures we call for from the concerned person. The contract will be filed by 13th of July post and closing.
Item 16, BA 5115 of 2026.
Your allegation is a petition and the other conclusion alleges that lately our woman was found in the garden of the petitioner. He made Allah and upon it the village people came and they tied her and they had beaten. All of them had beaten her. Said nothing. And subsequently during the treatments he died in hospital. Both news has been granted bail by this honorable and the coordinator. So Rashid has been submitted.
There is no specific allegation against
Allegation that I had made the Allah about that woman, or subsequently everyone came and then she was beaten. Tetra. Upon my Allah only everyone had come.
or the Royal Council appearing on behalf of the petitioner. The Royal Council for the petitioner submits that the petitioner has been falsely implicated in this case. And it is alleged that one mentally disturbed / unbalanced woman was found in the house.
Yes, in the garden.
In the garden of the petitioner, and when petitioner raised alarm, the number of persons gathered and she was assaulted and ultimately she succumbed to the injuries. He submits that there is general and omnibus allegation and there is nothing against the petitioner. Co-accused namely Biswa Rao and Chandrashwar Rao, has been enlarged on bail in DA number 4172 of 2026. And another co-accused, namely Shivlal Rao, has been enlarged on bail in DA number 4949 of 2026. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and upon moving to the appeal order, it said it is apparent that on the basis of confession statement of the petitioner, the name of the co-accused had transpired and blood-stained rope and danda used by committing the offence was recovered from the petitioner upon his disclosure. In view of the aforesaid, this court is of the considered view that the case of the petitioner is not similar to that of the other co-accused persons. Accordingly, this court is not inclined to enlarge the petitioner on bail.
Item 17, BA 5119 of 2026.
This petitioner.
Cybercrime के केस में 3 persons were arrested and for their mobile phones SIM card recovery committed.
क्या है आपके अगेंस्ट?
एक एंटीसीडेंट है, हम लिखेंगे जिस पे बेल वो एक 3 लोग पकड़ाए थे।
कस्टडी कब से?
17/2/26 चार्जशीट है इन सबमिटेड। 3 लोग एक साथ पकड़ाए थे, एक का बेल हो गया।
One antecedent of similar nature.
ये लो ठीक।
उसमें बेल हो गया?
हाँ, उसमें बेल हो गया।
बेल उसमें कब हुई?
ऑर्डर लिखा है ऐसे। इसमें विक्टिम के बारे में कुछ अपने नहीं है, लेकिन इंक्लूडेड है कि देयर आर सम विक्टिम, लेकिन 3 लोग पकड़ाए थे, तीनों के पास मोबाइल फोन सिम्स वगैरह रिकवर हुआ था, सबसे में कुछ ऐप वगैरह डाउनलोड होने का इंडिकेशन था। एक कोई एक्यूज्ड को बेल हुआ है जो साथ में पकड़ाए थे।
इनके अगेंस्ट में एफआईआर में क्या है?
In order में लिखा हुआ कि that the statement of various victim of cyber crime committed by these persons is also reported in para 36, 37, 38 and 39.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that.
Actually डायरी नहीं है।
Reject कर रहे हैं।
इसमें these accused persons लिखे हैं, एक का जो है similarly situated
no victim had come forward to lodge the complaint.
स्पेसिफिक पिटिशनर के अगेंस्ट में इंप्यूड ऑर्डर में भी नहीं आया, तो डायरी ही अटेंडेंस हुआ सर्टेन हो जाता कि
कोई स्पेसिफिक नहीं है। आपके अगेंस्ट में कुछ नहीं आया, विक्टिम नहीं आया।
नहीं, इंप्यूड ऑर्डर में है कि
लिखा हुआ नो विक्टिम हैज बीन आइडेंटिफाइड, तो हम क्या बोलें?
हम बस ये कह रहे थे कि डायरी आ जाता तो स्पेसिफिक का सर्टेन हो जाता कि किसके अगेंस्ट में विक्टिम है, किसके अगेंस्ट
नहीं। आपका एंटीसीडेंट है, कुछ दिन बाद आएगा। ये नंबर 5119 of 2026. Heard the learned counsel appeared on behalf of the parties. The petitioner is in custody since 17/2/2026 and charge sheet has been submitted. The learned counsel for the petitioner has submitted that the co-accused has been enlarged on bail in BA number 4780 of 2026 by the order dated 2/6/2026. The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioner has criminal antecedent of similar nature, to which the counsel for the petitioner submits that he has been enlarged on bail in the other case. In the statement, after hearing the learned counsel for the parties, this court is upon perusal of the impugned order itself, it appears that The statement of various victims has been recorded in various paragraphs of the case diary, and the further investigation is also going on. And the petitioner also has a criminal antecedent. In view of this fact, this court is not inclined to enlarge the petitioner on bail so far as the bail of the accused person is concerned. It was submitted in that case that the petitioner does not have any criminal antecedent. Therefore, the case of the petitioner, and also that no victim had come forward to lodge any complaint.
At this stage.
Until at this stage.
Item 18, BA 5122 of 2026.
Yes, petitioner.
This case, is administered as section 4 and 6 of the POCSO Act and the other sections. The first information report has been launched by the mother of the my prayer before the lawsuit would be that what is the statement part that is not working. That is statement of victim part for the
Mentally disabled has
no, that is not, that is because I have mentioned that she was mentally fit mallet and she was also physically mallet as per my information. And her statement, and she has given a different story. A meeting from the case of investigation. That's why there is matters the statement of victim or somebody
FIR पढ़िए sir.
Yes. Page 9. Sorry, page 11. ये रहने वाली हूँ मेरी बेटी उम्र सच एंड सच उम्र 14 वर्ष जिसका दिमागी हालत ठीक नहीं है वो डरी और शर्मी रो रही थी जब मैं पूछा इशारा करते हुए बताया कि मैं नहीं गांव के चाचा सच एंड सच ने चाचा ससुर सच एंड सच ने इशारा करते हुए बताया कि मेरी बेटी के घर बुलाकर कॉलोनी पक्का घर में ले जाकर गलत काम किया तब मैं सच एंड सच के घर जाकर पूछने लगी तो सच एंड सच ने दोबारा गाली गलत धमकी देने लगा यह बात किसी को बताओगी तो थाने में जाओगी तो तुम्हारे पूरा परिवार को जान मार देंगी मैं डर से किसी को नहीं बताई
Direct allegation against you.
as per that she is not the victim rather the daughter is the victim on her statement well otherwise the statement of victim.
Should I record his submission?
Well, I have got a copy of the diary that from here, my lords. I am submitting before the lords.
Just a moment.
जी उसका निकाल
As the learned counsel for the state is directed to serve notice upon the involvement of the case and file a counter affidavit in this case. Let the case diary be called for from the concerned court along with statement of the victim recorded under section 183(26) and a medical examination. The counter affidavit be filed by 13th of July, post on 14th.
Item 19, BA 5126.
It is all clear. The counsel for the petitioner has submitted that victim has not supported the prosecution case in a statement recorded.
Supported different story, but I am not saying that.
Has given a different story in a statement recorded under section 183 BNS.
Item 19.
Petitioner is not named in the FIR also. The informant has submitted an application that his sister so and so has been in touch by the holder of mobile number so and so on for solemnizing marriage, for the purpose of solemnizing marriage.
Petitioner the victim has been recovered.
Recovered, हाँ.
From where?
तो घर से और इसमें इनपुट ऑर्डर में आया हुआ है इनपुट ऑर्डर के पेज 18 में देखा जाएगा पेज 18 है इनपुट ऑर्डर का सेकंड पैराग्राफ का 6 लाइन
ऊपर से पढ़िए ना यहाँ से पढ़िए पेज 17 से पढ़िए
The instant petition has been filed on behalf of the
नीचे heard and produced.
Heard learned counsel for the petitioner.
Then heard and produced the case record from which it appears.
Heard and produced.
Internal page 2.
internal press group. Yes. Order to produce the case report from which it appears at the state case administrator on the basis of detailed report of the info come brother of the victim, alleging therein that in 15/2026 at 6 p.m. the owners of mobile number so and so had enticed her minor sister appear on the pretext of marriage. In this act of kidnapping, Priya Devi, Parmila Devi, Ramvilas Paswan, Aparit Khatun were invoked against this case. On further perusal of the case report as well as case study, it transpires that the informant has supported the occurrence in his re-statement at para 4 of the case study and other witnesses, namely Neelu Kumari Madhu Paswan, have also supported the prosecution case in their statement at para 6 and 17 of the case study. Thereafter, by from perusal of the statement of victim recorded under section 183 BNS, that is 164 CRPC, it appears that the victim has stated that she on her own record went to the accused or petitioner as in love affairs. From the perusal of case report appears
What do you say?
Yes, my lord, his victim age is 16 years. And recorded over
Counsel for the state is directed to serve notice upon the involvement of the case and file a complaint. Let the case diary be called out from the concerned court along with the statement of the victim recorded under section 183 BNSS and her medical examination.
Medical examination refused to undergo medical examination. Case study
Medical
Maya.
examination report is pending. Post on 14, count affidavit will be filed.
Item 20, BA 5130 of 2026.
Case under section 82 of BNSS complaining to 304B of IPC. There is a petitioner is the sister-in-law and she resides another place, but there is allegation that the husband and mother-in-law and brother-in-law and sister-in-law has been threatened, and there is no specific allegation against of demand of dowry, and the deceased died and she married in 2023. Lordship. The petitioner is sister-in-law. There is no rule of even there is no. हाँ Lordship. Page 15. सैन्य निवेदन है कि मैं अमरदेव चौधरी पिता फला हूँ पलामू रहने वाला। मैं अपनी बेटी संध्या कुमारी उम्र 24 वर्ष जिसकी शादी वर्ष 2023 में रविंदर चौधरी ग्राम देवरी पहाड़ी पर पंचायत के देवरी कला पोस्ट जपला हुसैनाबाद में साथ हुआ था। शादी के 6 माह बाद मेरी बेटी के साथ ससुराल के सभी लोग दहेज में कम पैसा देने और काली कहकर मेरी बेटी के साथ मारपीट करने लगे और उससे प्रताड़ित करने लगे। मेरे बेटी के पति भी मेरे बेटा के साथ नहीं दे रहा था, जिसको लेकर अपने रिश्तेदार के साथ देवरी पहाड़ी पर आकर पंचायती के माध्यम से मेरे बेटी के ससुराल के लोग को समझाए। पंचायती में मेरे बेटी का देव प्रदीप चौधरी, सास और मेरे बेटी का ननद प्रतिमा देवी द पिटिशनर और ननद के
क्या बोलना
लड़का प्रिंस चौधरी पंचायती में धमकी दिया।
Yes, general law allegation है। Basically इनके बेटा पर allegation है, Prince Chowdhury।
Husband is liable.
And she's married, right? कहाँ रहते हैं?
पोस्टमार्टम में आया है कि लिगेचर मार्क है।
हाँ?
लिगेचर मार्क है तो जब सुसाइड करेगा तो लिगेचर मार्क होगा ही।
मैरिड सिस्टर इन लॉ को जनरल ऑमनिबस एलिगेशन में कितना गिना देगा? प्रिंस कार्ड का प्रपोज करिए।
हाँ 25/2/26 से हम कस्टडी में
चार्जशीट हो गया ना?
हाँ चार्जशीट।
For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is married sister-in-law and has been made an accused in this case. He submits that though the victim died in a matrimonial home within how many days of marriage?
Within 3 years of
Within
marriage.
3 years of marriage, and there is general and omnibus allegation. The learned counsel for the general and omnibus allegation regarding demand of dowry and assault. The learned counsel charge sheet has already been submitted in this case. The learned counsel for the state has opposed the prayer for bail. However, the opposite submissions are not in dispute. After hearing the learned counsel for the parties and considering the fact that the petitioner is married sister-in-law of the victim and there is general and omnibus allegations against the petitioner, charge sheet having already been submitted, the petitioner is entitled to be indulged on bail.
Item 21 BA 5132 of 2026.
In this case, it is also there were cyber case. There's one more another case with the same case number, which has been kept on 1st of July 2026, Lordship 5031 of 2026. So I would record the same order was passed in serial number
Also,
2.
for the petitioner submits that this case will be tagged with VA number 5031 of 2026, which is already scheduled to be posted on 1/7/2026. Case ID has already been called for in that case. Also, for the state is directed to file a counter affidavit in this case, along with the criminal antecedent report of the petitioner. Clearly indicating as to whether any case has been registered against the petitioner in the state of Jharkhand or in other state, depending upon the complaints which might be reflected in the portal. Complaint का कोई FIR हुआ है कि नहीं? This is what I'm looking for. किसी का 5,000 रुपए चला जाएगा, 5 लाख रुपए चला जाएगा, खाली वो कंप्लेंट करके नहीं छोड़े। लेकिन ये लोग ये इन्वेस्टिगेशन करके नहीं पता कराते हैं कि उसका कोई कॉरेस्पॉन्डिंग FIR ये नहीं पता चलता या नहीं करते होंगे, वो लोग खाली एक्नॉलेजमेंट करके छोड़ देते हैं। वो सब First July.
Item 22 BA 5133 of 2026.
Main list on documents. The FIR is under section 103 subclause 1 and section 35 of the BNS Act. The FIR has been drawn against 3 accused persons. One petitioner has come forward for the matter of radio pay.
Are you named in the FIR?
Yes, ma'am. I'm named.
Who has lost the FIR?
The deceased father.
Is an eyewitness?
No, he was given information according to the allegation which is there in the he was given information from petitioner's brother that your daughter is not feeling well and definitely something might happen to her. Pursuant to the methods, he has come and he has found his daughter to be dead. Now,
when was the marriage solemnized?
There is no case of marriage minutes.
His daughter was found dead?
I am not the husband. I am the caretaker of this entire family. His daughter, the informant's daughter, was given on adoption to me and my family when she was 4 years old. Apparently, there was some kind of scuffle that took place. Pursuant to this information was given to the informant, and then when he appeared, it was found that the girl has committed suicide. According to our version.
4 years old girl.
No.
Committed suicide.
No, 4 years. When she was 4 years old, we have taken it for adoption.
Okay. And
now
she committed suicide.
She has committed suicide after attaining majority. There is no postcode. And that this argument of mine is substantiated with with the observation made by the trial court, it needs improvement. Court says that yes, she has drowned because of asphyxia and there is water in her lungs. And you see the last
She has committed suicide.
Yes, please. Can you see the last paragraph?
What was her age at the time of death?
Unfortunately, my notes, I was actually looking for that age. That has not been mentioned immediately.
Counsel for the state is directed to file a counter affidavit and serve notice upon the informant of the case. His daddy has been served. The charge let that his daddy be called for from the concerned court along with its enclosure, including the postmortem report and the inquest report.
Much respect.
The counter affidavit be filed by 13th of July 2014.
Item 23, BA 5137 of 2026.
Also, the case has been filed under the Commission of Cyber Offense. One mobile phone and 2 SIM cards have been recovered from the petitioner. His name has transferred only on the basis of self-confession statement, and there is no whisper about that what offense was committed by him and to whom he has cheated. There is simple allegation that with the help of an RTO APK file, they used to defame and extract money.
There is no recovery from you.
There is recovery. One mobile phone and 2 SIM cards.
Counsel for the state is directed to file a counter affidavit in this case, along with
This
criminal antecedent report of the petitioner.
No antecedent lawsuit from February.
Your statement is not a gospel truth. We will verify it by the affidavit of the state. Correct? वो जो स्टैंडर्ड हम लोग देखते हैं इसमें साइबर क्राइम में टेकिंग इंफॉर्मेशन फ्रॉम द पोर्टल वैसा ही काम let the case ID be called for from the concerned court along with its enclosures. इसमें कोई भी उसका कहाँ बाकी सबका क्या all of them have been enlarged on bail.
No, there is one more who has not filed. He has not filed.
Post on 14 July, counter affidavit be filed by 13th.
Item 24, BA 5140 of 2026.
Yes, petitioner.
Yes, sir. With the bill application earlier rejected, the coordinate bench of the shore of the court matter. Thereafter, not the charge rating framed and victim has been charged matter.
When was charge framed?
Charge from this date did not come matter, but thereafter, not victim has been examined as PW1 matter.
How many witnesses have been examined?
PW2 matter, 2 witnesses has been examined matter.
So she has not supported, she is hostile.
Not hostile matter, but it is contradiction matter.
How many witnesses are remaining to be examined? How many witnesses are remaining?
Yes, ma'am.
Yes. You heard the learned counsel's opinion on behalf of the parties. Counsel for the petitioner submits that the bail application of the petitioner was rejected on merits earlier in BA number 10021 of 2023 by the order dated 6/2024. The learned counsel submits that though the victim has been examined as PW1, PW2, but she has not fully supported the prosecution case in as much as there are numerous contradictions in her evidence. The learned counsel for the state has opposed the prayer for bail and has submitted that the remaining witnesses will be promptly produced before the court. After hearing the learned counsel for the parties and considering the fact that the bail
Custody मतलब 30/7/2023 से
हाँ करा दे कस्टडी दिखाइए 30/7/2020 Considering the seriousness of offence alleged against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court, so that the trial is taken to a logical end. कोई FSL है इसमें? लग नहीं रहा। I don't think so. That is any FSL. The council for the state is directed to communicate this order to the director of prosecution and SP of the concerned district.
काम दे तो 3 साल लगभग कस्टडी में होगी।
आपको अगर विटनेस नहीं आए ना तो आप आ जाइए, फिर SP को कंटेम्प्ट और आपको बिल।
Item 25 BA 5141 of 2026.
In this within yes, he said that on the pretext of page 11, there was relation for last 3 months for marriage. Page 11. Small type. निवासी में मुझे शादी करने का झांसा लेकर उम्र 18 वर्ष पिता विनोद बावरी स्वयं झांसा लेकर मुन्ना कुमार यादव स्वयं ग्राम रानीबाग स्वयं बाला फुसलाकर बोला कि मुझे शादी करेंगे। वो पूर्ण रूप से मुझे विश्वास लेकर मेरे साथ लगातार 3 महीने से
Counsel for the state is directed to serve notice upon the victim and file a counter affidavit in this case. SC, ST, so caste का कुछ बात बोला है।
कास्ट का बात कुछ बोले नहीं, सीज SC ST बोले ऐसा ही कहीं नहीं। There is no SC ST.
SC ST बोले नहीं है, लेकिन SC ST है।
हाँ।
SC ST के साथ इस तरह का ऑफेंस होने का अलग कंट्रोल।
अलग constitution. But on the pretext of marriage, this is the case.
Let the case diary be called for from the concerned court, along with the statement of the victim recorded under section 183 BNSS, and also the medical examination report of the victim. देखते हैं थोड़ा दिन में। Victim को सुन के Post on 14, counter affidavit will be filed by them.
Item 26 BA 5143 of 2026.
Yes, petition.
Initially, FIR was lodged under section 80 and 61(2) of BNS. However, subsequently, police, after investigation, submitted charge sheet under section 108/3/5 of BNS. But as far as this petitioner is concerned, she happens to be the mother. My lord has granted bail to 2 persons, my lord. One sister-in-law, unmarried sister-in-law, and one brother-in-law. Brother-in-law.
Mother-in-law for the allegation.
And general and vague allegation against all persons, my lord, as far as my lord, the reason, my lord, it is said, my lord, that she was suffering from epilepsy. And she, this was suppressed, subsequently it was detected, she was being treated. She has committed suicide, and after commission of suicide, my lord, they have lodged the case, they have ransacked the house of the this petitioner, my lord, set the house on fire, for which, my lord, this petitioner has lodged FIR through, has sent the complaint to the, for lodging FIR that has not been lodged, as she has sent this from the hospital, from the custody. Annexure 2, Annexure 3 is my complaint, my lord. And as far as, my lord, allegation against the petitioner is concerned, my lord, there is general and vague allegation against all.
ये आगजनी का कौन सा काम है?
आगजनी ये लोग इसके बाद मेरा पूरा घर आ गया। हम
And it has come in the case diary also, madam, that they have set my house on fire. और ट्रीटमेंट का जो है हम लीव लिए हैं, जो डॉक्यूमेंट हमारे पास मोबाइल पर था, that I can.
Mother-in-law पे क्या allegation है? Specific होगा तो नहीं देंगे,
Specific नहीं.
Demand of dowry and
Specific.
Show me. Where is it?
Chief marriage was solemnized in the year 2025, May of 2025. Your current status.
2025.
May 26, 5/25.
May place
And the press has been taken place in the
January 26.
Within the 6
7 months.
Mother-in-law को bail देना थोड़ा मुश्किल लगता है.
My lord, may kindly have a look to the FIR.
Mother-in-law and husband.
हम
यही दोनों हैं.
I can understand,
परिवार.
but kindly have a look to the FIR. There is no specific allegation against the
Specific तो किसी पर भी नहीं होगा ना.
husband का हम भी समझ सकते हैं हमारे, but as far as the police has
ये बहुरानी घर में ही रहती है. Husband के साथ काम पे नहीं जाती.
as the police after investigation has submitted charge sheet only under section 118. But it has also.
घर में हुआ ना incident.
उसको I cannot deny, my lord. My lord, may kindly have a look to
This is the hanging position of the deceased.
May I place, my lord?
This is the hanging
Page
position
13,
of
my
the
lord.
deceased. Her feet was lying in the floor.
Mother-in-law को थोड़ा मुश्किल है.
My lord, as far as my lord, the postmortem report doesn't show any injury. My lord, save and accept that hanging mark, my lord. As far as my lord, if anybody is, my lord, after, my lord, if it is not a case of suicide, there cannot be nobody can be hanged, my lord, without any injury, my lord, without any force. My lord, admittedly, my lord, she has committed suicide because of her illness. She was suffering, and this matter has been reported, and there was panchayati. It has been admitted in the FIR itself, my lord. और जो कुछ भी डॉक्यूमेंट मोबाइल पर था वो हम रखें, बाकी घर में तो ये लोग आग लगा.
Or the learning council is agreeing on behalf of the parties. The learning council for the petitioner submits that the petitioner is the mother-in-law of the victim, but there is genuine and omnibus allegation upon all the accused persons. The charge sheet has already been submitted, and the petitioner is in custody since
27/1/2026.
27/1/2026. He has submitted that the two co-accused, that is the unmarried sister-in-law and
Ekdam,
one brother-in-law
brother-in-law of the deceased.
and her unmarried brother-in-law.
No.
Sorry.
Brother-in-law of the deceased.
Yes.
Ekdam.
Unmarried sister-in-law and her
Nandosi.
and one brother-in-law is Nandosi have been enlarged on bail by this court in DA number 4267 of 2026 and DA number 3349 of 2026. The learned counsel for the state and the informant have opposed the prayer for bail and has submitted that the marriage was solemnized on
6/5/2025.
6/5/2025, and the victim was found dead in matrimonial home on
20th January 2026.
21st of January 2026. And immediately prior to the occurrence, the victim had called the informant and described the incident which was taking place in her home. After hearing the learned counsel for the parties and considering the fact that, considering the nature of allegation and the fact that victim has died in matrimonial home within a period of 6 months, 7 months from date of marriage, and the petitioner is the mother-in-law with whom the victim was residing. This court is not inclined to enlarge the petitioner on bail. So far as the bail application of the court used are concerned, they are on different footing, inasmuch as one of them is the unmarried daughter, and the other one is the Nandosi, who certainly does not live.
No, my lord, Nanad was living in the same house. Unmarried.
Unmarried.
She is unmarried. She is unmarried.
Nandosi was not living in the matrimonial house.
If my lord will call for the case diary, everything will come out how I will.
Article 27, DA 5395 of 2026.
Yes, petitioner.
Broadly related by answer to because it is cybercrime other way to bracket with.
आपका antecedent भी है ना?
एक ही antecedent है, not there is
ये
one
organized
victim
crime है.
of only one victim of 9,000 other co-accused not.
केस कब का है? केस कब का है?
केस 25 है और जो विक्टिम जो आए हैं, जो मेरा मोबाइल नंबर है ना, उसका IMEI सब बाकी
दिखा नहीं, ऑर्डर दिखा।
सिंस मेरा एंटीसीडेंट
विक्टिम भी है कि नहीं, आइडेंटिकल है कि
आइडेंटिकल विक्टिम है हम लोग का भी। I have the data.
इनके ऊपर कोई स्पेसिफिक है?
नहीं, कोई स्पेसिफिक
इनके ऊपर है।
क्या बताइए?
विक्टिम भी है।
एंटीसिपेट विक्टिम तो सनी का है, बाकी सब का नहीं है।
सबका विक्टिम है। ऑर्डर में भी है, ऑर्डर ग्रांटिंग पे मेरे पास एंटायर केस डायरी भी है, सबका विक्टिम।
आपके केस में कितना विक्टिम है?
एक
कहाँ से बोलो?
72 एक विक्टिम है, वो भी
कहाँ से बोलो? आपका केस डायरी, आपका केस डायरी
already police paper has been received. I have received that police paper that I am seeing. एक विक्टिम है,
थोड़ा आप कस्टडी जान लीजिए,
मंगा लिए, कोई दिक्कत नहीं।
द लर्नड काउंसिल पर है, क्योंकि उस समय नहीं लगता है कि आपका केस डायरी नहीं हुआ था।
ये केस डायरी
नहीं, आपका डिटेक्शन के टाइम केस डायरी हुआ।
हाँ, डायरी था, डायरी के बाद चूंकि हाँ एंटीसीडेंट था, वो अदर कोई एक्यूज का एंटीसीडेंट नहीं था तो बेल हो गया था, मेरा एंटीसीडेंट था इसलिए।
The learned counsel for the petitioner submits that the bail application of the petitioner was rejected earlier in bail number 1282 of 2026 by the order dated 9/4/2026. the charge sheet has already been submitted, and considering the custody, the petitioner has renewed his prayer for bail. He has submitted that he has one criminal antecedent, and in the present case, one victim was identified, which is apparent from the order rejecting the bail application of the petitioner. He has also submitted that the other co-accused persons, namely Manbar Ansari and Sahil Ansari, have been enlarged on bail by this court by different orders. ये तीन order हैं ना? Alfaz Ansari have been enlarged on bail by this court. The bail application of the petitioner was rejected primarily on account of criminal antecedents. Isn't bail okay?
Also bail
The learned counsel submits that the petitioner has already been enlarged on bail in the case in the other case registered against the petitioner. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and custody and considering the custody of the petitioner since 10/12/25 and also that other co-accused persons have been enlarged on bail, the petitioner is admitted to be enlarged on bail.
Permission item 28, BA 9585/2025, long 29.
Case registered under section 302, 201 on 20B. Charge sheet has been submitted under section
302,
201, 201
and 120B.
120B. Charge sheet has been submitted under section
Tell me. Section number
302, 376D,
376D.
201 and 120. Petitioner in custody मानो 9/2/2022 4 साल 4 महीना से other the husband of the deceased granted bail by the next 2 months. The prosecution case is not only
Husband of deceased.
minor.
Husband of deceased.
Minor.
ये 376 DVS.
Minor.
Husband.
इसमें पढ़ते हैं FIR को पढ़ते हैं पेज 12.
But putting us same note as it was husband is in the jail custody at the time of incident.
हम भी कस्टडी में वो जो जरा पढ़ लेते हैं इसका FIR. निवेदन पूर्वक कहना है कि मैं संतोष कापरे 150 ग्राम 150 ग्राम गोटा 55 ग्राम अस्पताल बस स्टैंड के बगल थाना देवरी.
आपका बेल एप्लीकेशन का ले लीजिए.
नहीं फ्रेश फाइल और हम एट द टाइम ऑफ ऑफेंस आई
ये कितना है? BA नंबर 6019 ये किसका ऑर्डर?
6019 ये मेरा फ्रेश फाइल वो भी ज्यादा था.
नाम आप काट दिए तो उनको कैसे पता चले? ट्रायल क्यों नहीं कंक्लूड हो रहा है? Yes?
Yes, my lord, I shall
क्यों नहीं हो रहा है? What do you mean? What do you mean? Why the trial is not being concluded?
At the time of offense, I was in jail custody. Date of offense है 18 हम लिखे हुए पहले लाख में. Date of offense है बोलिए 18/10/2021 और हम 14/10/21 से ही कस्टडी में थे. और इसी ग्राउंड पर हस्बैंड का भी बेल वाजिब एक्सेप्ट हुआ है.
दो
इसमें केस है वो जो डिसीज का शादी हुआ जो विकास इसका विकास कुमार केवल निवेदन पूर्वक कहना है कि मैं संतोष कापरी 19
पिता स्वयं थाना स्वयं विकास में ग्राम वास्तव बस स्टैंड के बगैर थाना जरूरी जिला दुमका का रहने वाला हूँ। मेरी भगिनी प्रियंका कुमार दुमका गाँव सुंदरगढ़ पिता स्वयं ग्राम देवी थाना रामेश्वर जिला दुमका एक माता एवं पिता बचपन में मिले गए थे, जिसके कारण मेरी भगिनी प्रियंका कुमारी बचपन से ही मेरे घर में रहती थी।
नाम जी बोलिए, नाम जी बोलिए।
जिसका कारण मेरी भगिनी स्वयं से बचपन से मेरे घर में रहती, जिसका पालन पोषण करते थे। दिनांक 24/9/2020 को मेरी मोबाइल नंबर स्वयं पर फोन आया। मेरी भगिनी ने बात किया, उसने कुछ तो बताया कि विकास कुमार केवल जो कि ग्राम देववाड़ी इंदिरानगर थाना नगर जिला दुमका मंडल से प्यार करती हूँ। दिनांक 25/9/2021 को अब अपना आधार कार्ड साथ लेकर घर से बिना बताए घर से निकल गई। कुछ दिन बाद विक्टिम अपना भाई राहुल को फोन कर बताई कि विकास कुमार केवल से शादी कर दुमका में रह रही हूँ। आज दिनांक 18/10/21 को सूचना मिला कि मेरी भगिनी की हत्या हो गया है। जब मैं सूचना पर ग्राम बेगिया के ग्राम लड़की का शव पड़ा हुआ है, जिसको देखने पर पहचान किया, उसको गले में काला दाग का निशान था। इस घटना से पूर्व मेरी भगिनी द्वारा बताया गया था कि मेरे पति की उपस्थिति में दुमका के कुछ लड़कों द्वारा पति के साथ मिलकर मेरे साथ हत्या किया। सूचना पर मैंने अपनी भगिनी को केस करने को बोले थे। मेरी शंका की मेरी भगिनी की हत्या अपने पति विकास कुमार केवल के सहयोगियों द्वारा ग्राम बेगिया के जंगल में गला बराबर कर विकास कुमार केवल का बेल हो गया है। जो हमने जिस दिन घटना घटी है 18/10 को होती, हम 4 दिन पहले से हम जेल में थे और हमारा 4 साल 4 महीना 9/2/22 से ही हम कस्टडी में।
किस केस में आप जेल में थे? कहाँ से पता चलेगा आप जेल में?
दूसरे
But where will I get this that you were in jail?
इसमें मुझे नाम लिखे हुए हैं।
आपको लिखने से होगा क्या? किस कब से आप जेल में?
हम लिखे हुए 14/10/21।
कोई आपका रिमांड ऑर्डर है, कुछ लगाए हैं?
हम सब तो नहीं लगाया। खाली लिखे हैं कि दुमका टाउन केस के साथ 255/2023 380 का केस था। उस केस
कब से
में
जेल में?
हम 14/10/2021
14/10/21 से आप जेल में।
जी।
But the allegation is that you have committed rape upon her much prior. That is the allegation.
एलिगेशन है।
तो फिर
ये तो उसके विकास केवल पर भी है कि उसका सो पर हस्बैंड उसका कह रहा है, उसी से शादी भी नहीं करता, उसी के नाम पर कस्टडी ग्राम पर उसको जेल दिया है। पेज 13 में है विकास कुमार केवल।
डीएनए में भी आपका मिल गया, आपको क्या चाहिए? चलिए, थर्ड मिलेनियम काउंसिल से ट्रेनिंग ऑन बिहाफ ऑफ द पार्टीज। किसके साथ है? वो कहाँ है? ऑनरेबल जस्टिस राजेश कुमार के यहाँ आप मूव किए थे पहले?
नहीं, ऑनरेबल जस्टिस नाम भी नहीं था।
वहाँ से ऑर्डर हुआ था अपील में, ऑनरेबल चीफ जस्टिस देखना होगा।
देखिए तो एक तो बहुत जरूरी है देखना।
Last time that matter has placed a different much order. Now, as because this matter goes to his honorable court, that's why the matter has been transferred to this court against the only matter. That's why.
और the current council secretary on behalf of the parties, the
इसमें
current council
कंसिडरेशन है कि 4 साल 2022 से है।
एक trial after expedient. Heard the learned council secretary on behalf of the parties, the council for the petition submits that the petitioner is in custody since 9/2/2022. And the co-accused has been enlarged on bail. Where is the bail order?
Annexure 2 page 13 में।
by order dated 13/10/2023, EDA number 6019 of 2023, who was the husband of the victim. The learned counsel has further submitted that the petitioner has been falsely implicated in this case in view of the fact that on the date of FIR, he was in
Date of
judicial-
occurrence. Date of occurrence.
Date of
one
FIR. Occurrence का तो date नहीं है exact. On the date of FIR and
इसमें मुझे है 21/10 को हुआ कि
and also on 21/10/2021, the petitioner was in judicial custody in connection with another FIR. The learned counsel called state कितना witness examination आपको नहीं पता कस्टडी के ग्राउंड में आएंगे तो स्टेज तो पता करके आना चाहिए ना. The learned counsel for the petitioner is not aware as to how many witnesses have been examined so far and what is the stage of the case. The learned counsel for the state has opposed the prayer for bail and has referred to the counter affidavit and has submitted that as per DNA profile, the DNA profile of the petitioner has been found matching with that of the victim. And as per the FIR, the incident had happened a few days earlier. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and the counter affidavit as pointed out by the learned counsel for the state, this court is not inclined to enlarge the petitioner on bail. However, there can be no reason for the state not to produce the witnesses, particularly when the petitioner is in custody since 9/2022. The state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution to ensure compliance. दूसरा कौन सा है? ये किसका है? Same.
नहीं.
Whose case is this? BA number 3845 of 22. Co-accused.
Same matter, almost same matter.
लेकिन उसमें क्या हुआ था यहाँ हाईकोर्ट से होने के सुप्रीम कोर्ट से इसका से डिसाइड हुआ था यहाँ का भी.
Order has been granted under appointment bench law, but that has been
challenge for the honorable apex court.
आप भी कहते हैं उस केस में भी
नहीं वो तो फ्रेश फाइल.
उसके बाद ये फ्रेश एप्लीकेशन फाइल. ये कब से चल रहा है? 2022 का बिल एप्लीकेशन. इनका सरेंडर सर्टिफिकेट फाइल हो गया. There is a petitioner. All the necessary steps have been taken to arrest the petitioner.
Order has been called from the on 22/8/2025.
So what is the present status? आप पता करिए.
Present status.
Have you arrested him? as per the last order passed by this court, which is dated 22/8/2025, in DA number 3845 of 2022. A report was called for from Superintendent of Police Dumka, and it was reported that all necessary steps were taken to arrest the petitioner. And the bail application was consigned to file. तो ये automatic कैसे लगा? इस ऑर्डर के बाद ये ऑटोमेटिक कैसे लगती है और उसके बाद कोई ऑर्डर ड्रॉ हुआ है? The learned counsel for the state is directed to seek instructions from the SP of the concerned Superintendent of Police Dumka with regard to present status regarding arrest of the petitioner of this case. It is important to note that in terms of, it is important to note that in terms of order dated 11th of July 2023, the petitioner was directed to surrender. It was directed that the present petitioner, who was the respondent in the same case, was directed to surrender within 2 weeks, failing which it was open to the investigating agency to arrest the petitioner. And it was further directed that the bail application of the petitioner will be considered by this court only after the petitioner have surrendered. Yes, madam.
Yes, Your Worship. Subsequently, the file was taken. I have already informed to them before that honorable court also कि call for report करिए because I don't have any instruction long by it.
Yes.
Whether he has surrendered or not, and we don't have the numbers because we don't keep the parties numbers.
You file a report, fresh report.
Because they'll just find out from the concerned court whether he is surrendered or not.
Not from the concerned court, from the superintendent of
I
police.
guess
Let a report of this in this connection be called for from the concerned court. वहाँ से भी मंगा लेते हैं, वहाँ भी pending होगा.
Yes, Your Worship. Whether he is surrendered or not.
And the entire order sheet, right from July 2023, be placed on record.
Through affidavit has to be filed.
This report should also indicate as to the status of the co-accused in the case. Split 2 hour to 2 hour.
Yes, yes, Your Worship. Split 2 hour.
This is from Ranchi.
No, don't go.
You have to file a contract.
It is.
The counter affidavit should specifically state as to what steps have been taken to arrest the petitioner after 22/8/2020. एक बच्चा हाँ डेट पोस्ट ऑन 13 जुलाई.
पासवर्ड केस आइटम 13.
अभी कुछ बच रहा है आपका कोई मैटर है क्या? 30
बच रहा है.
एक बजे के लिए रखे थे ना
हमारा
आपका है 1 बजे के लिए.
थोड़ा नमाज पढ़ने जाना है हमारा 2:50
कितने का चाहिए?
2:50 15 में नहीं अब एडजर्न हो जाएगा, आप
नहीं
जाइए
तो नहीं कर लिया
इनका कर लीजिए।
Item 30.
हाँ
हाँ बताइए सर।
Lord, as per FIR, there is a arrest section 87, 366 of the IPC and 196 BNS 366A. As per FIR, there is allegation that petitioner along with page 16, along with the page 16, taken away the daughter of the informant from the house, page 16. And a statement नाइस 1:26 समय रात्रि 8 बजे मेरी नाबालिग पुत्री सगीरा खातून उम्र 15 बरस जो +2 विद्यालय में की छात्रा है बकरी को पेशाब कराने के लिए घर के बाहर सड़क पर गई थी। उसी क्रम में पहले से घात लगाए मुर्शिद से कृष्ण और उसके साथ अन्य 2 युवक 2 मोटरसाइकिल में जबरन उठाकर अपहरण कर उनके उद्देश्य से लेकर चला गया। खबर की सूचना पाकर गांव के 2 व्यक्ति मुर्शिद शेख के घर गए, जहां फेजूर शेख और रुहुल शेख 50 वर्ष से उन लोगों को बताया कि राजमहल थाना अंतर्गत स्थित अपहरणकर्ता के मौसी के घर तुम्हारे पुत्री की शादी हमारे पुत्र मुर्शिद के साथ करा दिया गया है। तुमको जो करना है करो, हम लोग तुम्हारी पुत्री को वहीं नहीं लौटाएंगे। मेरा पति और पुत्र मुंबई में मौजूद कर दें। After 8 days of the occurrence, Lordship, FIR has been registered. And as per the statement of the victim, my lord, case diary was called for my lord. Statement is there, my lord. I am reading the statement of the victim, my lord. इस समय कांड की पीड़िता
Victim कौन है? You are there?
Sagina, daughter of the informant.
I am mother of the victim.
What do you have to say? She was minor?
Yes. She was
You are
minor. She is
opposing?
16-year-old.
You are opposing? बताइए शादी करनी है क्या?
Kindly appreciate, my lord. Kindly appreciate the statement. Kindly appreciate, lord.
कौन सा statement?
Of victim. In case diary.
Page number. आपके पास आपके अगेंस्ट में सिमिलर नेचर ऑफ अनदर केस में
No, similar to 498 है. 498 है, my lord. After para 70 separate seat में है.
नहीं आप बताइए आप पैरा 70
उसके बाद सेपरेट सीट में लगा हुआ है। ये अपने बयान में बताई कि सेपरेट सीट para 70 के बाद। पहले 70 के बाद सेपरेट सीट में लगा हुआ है।
Page 73 है ये कांड
77। इस समय कांड की पीड़िता सगीरा खातून उम्र 15 वर्ष 50 वर्ष हो, ये अपने बयान में बताई कि इनका मुर्शिद शेख 50 वर्ष हो राय साहब से पिछले 7 महीनों से प्रेम प्रसंग था और उसी से शादी करना चाहती थी, परंतु इनके घर वाले शादी के लिए तैयार नहीं थे। दिनांक 19/1/2026 को समय 8 बजे रात्रि को मैं मुर्शिद शेख के साथ अपनी मर्जी से घर में बिना किसी को कुछ बताए मुर्शिद शेख के साथ भाग गई। हम दोनों मंडैया स्थित मुर्शिद शेख के मौसा रूहुल शेख के घर में गए और फिर वहां से मौसी शेख की मौसी के घर महेश्वरपुर चले गए। इसके अलावा कोई नहीं बात। एंड माय लॉर्ड
एज तो बहुत कम है।
एज कम है लॉर्डशिप,
एज बहुत
15 years my lord,
और
currently
15 years बहुत बड़ा एज नहीं होता है ना।
Yes. और इसके फादर घर पे नहीं है लॉर्डशिप, मुंबई में काम करते हैं ड्यू टू प्रेशर है लॉर्डशिप, इसीलिए वो ऐसा बयान दिए है। और लॉर्डशिप सेम नेचर
रिपोर्ट भी मांगा गया था अबाउट मैरिज।
अपना स्टेज बताइए।
मैरिज
स्टेज बताइए।
स्टेज चार्जशीट सबमिटेड।
चार्जशीट कब हुआ?
सबमिटेड
कब?
डेट तो नहीं पता है। नेक्स्ट डेट इन लॉर्डशिप 3/7/2026 next date for commitment
3/4/2026
3/4/26 चार्जशीट हुआ।
3 next date is 3/7. Kindly appreciate lordship, both section is not applicable in this case lordship. Kindly appreciate my lord. As per statement of the victim my lord, there is no force was used. Kindly appreciate this section my lord, both section. Kindly appreciate.
भाई माइनर के साथ फोर्स है कि नहीं है इसका क्या लेना देना?
15 more than 15 years my lord. She is aged about more than 15 years and no force was used my lord. And kindly appreciate the both section.
आपका सिमिलर
नहीं सिमिलर नहीं ना है। 498 ए का है ना। 498 ए का है, किडनैपिंग का नहीं है। 498 ए का है। काइंडली अप्रिशिएट।
हम अप्रिशिएट कर रहे हैं, आप ऑर्डर में अप्रिशिएशन।
और एज जो है इनका 16
नहीं एज माइनर नहीं देखना।
16 ईयर 16 ईयर
शादी कराने वाले भी वैसे और शादी करने वाले भी वैसे।
16 इयर्स एज है और देखा जाएगा इसमें माय लॉर्ड काइंडली दोनों सेक्शन नहीं।
हम देख पेटिशनर इज वॉशिंग फाइल कर दीजिए, वॉश हो जाएगा आपका केस। दैट इज
बोथ सेक्शन माय लॉर्ड, नो किडनैपिंग नो
फाइल वॉशिंग ऑफ द एंटायर केस।
petitioner is a minor and in lordship जो criminal
रिपोर्ट
उसमें भी वो minor है, जिससे वो शादी की है वो भी 17 years old है।
एक रिपोर्ट मांग गया था अबाउट मैरिज, रिपोर्ट मांगा गया था, दैट इज देयर, रिपोर्ट इज देयर, काइंडली अप्रिशिएट।
I'm appreciating DA number 4022 of 2026. The learned counsel for the petitioner submits that the petitioner is in custody since 5/2/2026 and charge sheet has been submitted on 3/4/2026. He has submitted that the petitioner has been falsely implicated in this case and the victim was more than 15 years of age.
Withdraw my lord. Seek permission to withdraw this.
Tied up नहीं होगा, ये होगा। After some arguments, when this court was not inclined to enlarge the petitioner on bail, the counsel for the petitioner seeks permission to withdraw this bail application.
At this stage, kindly.
Accordingly, this petition is dismissed.
Kindly at this stage.
Pushing the 2 months.
Also, case at 13 DA 5102 of 2026.
I've been quite hurt about this matter. When bail order was passed, the bail order marks the bail application is because the concluding portion already is mentioned. The appeal will lie and returnable against the order passed by the special court for exclusive special court constituted under the provisions of the POCSO Act.
That's where is the other side? It's first time.
Yes, it's first time. Others have been granted bail, and the only allegation is that they were found in a hotel and they had created nuisance.
The learned counsel for the state is directed to file a counter affidavit in this case, along with the criminal antecedent report of the petitioner. Then the case diary along with its enclosures be called for from the concerned court. Charge हो गया है ना?
हो गया अभी तक तो नहीं
कब तक कस्टडी में?
2 months का इसमें कस्टडी का होगा, कस्टडी इज इन कस्टडी
अभी
सिंस
अभी तो इन्वेस्टिगेशन ही नहीं हुआ होगा।
कस्टडी सिंस 7/4 हो गया होगा चार्जशीट हो गया 60 days का होगा मैक्सिमम।
60 days होगा कि 90 days होगा?
60 days होगा इसमें।
The
कोई
council
ऐसा
for the
ऑफिस है नहीं,
petitioner has submitted that the charge sheet has been submitted.
must have been submitted.
Must मतलब क्या है? अगर 60 days है या तो हो गया होगा या कोई ऐसे ही
पोक्सो का
release हो
कुछ
गया
में
होगा।
90 days का है, पोक्सो में कुछ में प्रोविजन में 90 days है। अगर होगा तो फाइल कर देंगे तो सेक्शन।
ऐसे तो क्या ही
नहीं वो सबमिशन हमारा कटवा दिया, ऐसा नहीं कि गलत हो जाए उसका।
जब आपका सबमिशन लिखा आप सबमिशन करेंगे लेकिन लिखा ही नहीं
वो वाला गलत हो जाएगा। पोक्सो का मैं देखा तो उसके बाद लगा कि इसमें 90
90
days
days ही है
पोक्सो में 90
because तुरंत ही कर दिए इट इज एट द स्टेज ऑफ इन्वेस्टिगेशन अभी आपको क्या भेजना
उसको हम देख लेते हैं, उसको देख लेते
हैं। इट्स लिखे PA नंबर 5102 of 2026 council for the petitioner seeks adjournment। थोड़ा हो जाने दीजिए 90 days हो जाने दीजिए ना तभी केस डायरी करेंगे नहीं तो फिर क्या फायदा।
आ जाता है कि पहले मुझ तरह का कोई सीरियस ऑफेंस वो नहीं है पहले होटल में पाए गए उसके
एडजर्न करेंगे हम इन्वेस्टिगेशन स्टेज में
to file the copy of the charge sheet ये आपका था।
he submits that he shall file a copy of the charge sheet। कब रखें?
after 10 days कर दूँ।
Post on 15th July। अभी तो चार्ज शीट आएगा तब देखेंगे उसके बाद।
इसीलिए मोबाइल से अच्छा रहता है वो सीडी वगैरह सब आ जाता है व्हाट इज द एविडेंस बिकॉज़ must statement of witnesses must have been recorded.
The case diary we confirm from the concerned court along with its enclosures. The counsel for the state is also directed to file a counter affidavit with the criminal antecedent report of the petitioner. Since the counsel for the state is absent, such a copy of this order will be communicated to the office of learned advocate general for complaints.